Court, all rise, please. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give me your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Judge Milkey. To my right is Judge Ditkoff, and to my left is Judge Englander. And together we're your panel on all 6 cases today. I think the folks here are just for the first 3 cases, but if there's anyone from the later cases, I just want to say we're going to take a brief mid-morning break between the 3rd and the 4th cases. I want to assure everybody that we have read the briefs. We're familiar with both the facts and the arguments, and I say that because 15 minutes generally is not a lot of time, so we urge you to cut to the chase to the extent possible. That said, if you feel like you've made your points, there is no shame in sitting down early. As one of our former colleagues used to say, if you hit a home run, there's no reason to run the bases twice. And with that, I will call the first case of the day, 2022 P220, has a certain ring to it, Commonwealth versus PARHAM. And my apologies in advance if I mispronounce any names.
Pronounced it correctly, Your Honor. Suzanne Renaud for Brett Parham. Your Honors, with your permission, I'd like to start with the Frisk issue in this case because obviously there's the issue of the seizure in the first place creates perhaps a question of new law that would have to be resolved. But if the Frisk were resolved, assuming that the seizure was possible, then you could potentially avoid that in the first place. The other thing that I would like to mention that I did not mention in my brief is that, and you very well may be aware of this, that Karen K has actually been argued, and in the SJC, it's SJC 13170.
I'm well aware of the fate of Karen K.
I thought you might be, Your Honor. So, but I just wanted to make sure that that was clear, that I was aware of that status as well.
And I'm not nearly as educated as Judge Milkey, which is common. Karen K addresses what issue?
That was just a case that the lower court judge relied on to say that there was reasonable suspicion for the Pat Frisk, Your Honor. Okay, and it also goes to...
Oh, I know Karen K too now.
It also goes to another issue that is pertinent to this case, which is how do you decide when there is reasonable suspicion? Do you look at things with particularity, or do you look at the totality of the circumstances? And I think that that is a really critical issue. Sweeting Bailey, if you look at the 3 dissenting judges plus Justice Wetland, all look at particularity, and that was also something that was done in Evelyn and as the dissent did in Karen K. So we can look at each of the factors with particularity. And that is important here because what we are dealing with Mr. Parham, he walks into a house, he is a completely unknown entity. He ends up being an occupant, but they didn't know that at the time. But if he were an occupant, he is not a person for whom there is any suspicion of criminal wrongdoing, simply because a suspected drug dealer lives in this house. This is not a stash house. This is not a house where drug dealing was thought of.
So stop for a moment, because you said 2 things that trouble me, but I'm going to take the second one first, which is this is not a stash house. How do we know that? Because we don't even have the warrant affidavit in our record. Were you aware of that?
I was aware of that, Your Honor. It was the Commonwealth's burden to establish...
Appellant, you're saying the warrant affidavit was not put in during the hearing?
That is correct, Your Honor. There was no warrant put in during the hearing. The only place where it came out at all was in the Commonwealth's motion to the court. I was able to get a copy of the warrant because it is in the court's file, I believe in Dorchester District Court, but I didn't think that it was appropriate for me to put it in because it's not part of the record in this case. And it's the Commonwealth's burden to have put it in. They said in their papers that, and the judge here actually heard the case with Mr. Burt, and so she was familiar with what was going on, but it wasn't there.
Well, the judge was familiar with what?
With the warrant, because the warranted search, Mr. Burt apparently had brought a motion.
So the judge already had the warrant affidavit?
In theory, but that was for a different case, Your Honor. And she...
Really for a different case where we're talking about exactly, the cases are severed? Is that what you're saying?
Yes, Your Honor, they are not being heard together.
Well, are the cases severed? Are there two separate are they indictments? So Bert's indicted and this guy's indicted?
Yes, Your Honor, and they were...
Separate, they're not co-defendants.
They are not co-defendants. They're not being treated as co-defendants. And so procedurally, we obviously are in an odd place, but if the Commonwealth wanted to establish that there had been a warrant for any person present or for no-knock warrant, those things were not established here. All they did was establish, and based on the inferences from the police officer's testimony, is that this is Mr. Bert's house. This is where he lives. So this is the house of a drug dealer. It is not a drug dealing house. That is the most that they established. Not only that...
I thought it was in the record that sales of crack cocaine were occurring at this residence.
Your Honor, that doesn't...
I think that's there. It says it's a residence from which he was selling crack cocaine, somewhere in the record that I just read.
Your Honor, I am unfamiliar with that, and if that is the case, I apologize. I did not recognize that as being a factual issue in this case.
I'm having a hard time thinking about the issues in reverse order. So can we at least quickly deal with the first issue?
That's fine, Your Honor. I haven't really started speaking of the other yet.
Your principal argument on the first issue is Summers applies only to occupants.
That's right.
As it turns out, he was an occupant. And before we get to what the officer knew or could have believed based on objective facts, can we just deal with the first piece of that, which is the mistake of fact cases that I'm aware of all come in the opposite context, where the police believe something that it turned out wasn't true. And the question is, for example, did they have a parent? Did the person who gave them consent have a parent authority and that kind of thing? And then there's a whole body of cases on that. Is there any case you can cite us to where the police, as it turns out, could have searched, but they may not have known that at the time, a mistake of fact cutting in the other direction?
Nothing that I can think of off the top of my head, Your Honor, that there would be a mistake of fact that went in the opposite direction. And in this case, I think we also have to figure out
Why do we say it's a mistake of fact? He unlocked the door.
Well, he unlocked...
You're getting to the next issue.
Yes, he did unlock the door. So if it's a mistake that the police did not... So first of all, I think that this is really critical here, that this is a search warrant case. This is not a motor vehicle stop. It is not on the street. This is something where the police had the opportunity to find out who the occupants were, to know who the occupants were, know who lived there. The fact is that you can call it a mistake of fact, but if the police did not actually know any of this information and the Commonwealth couldn't prove that
Okay, but let's then get to Judge Englater's point, which is you had someone show up out of the blue through a locked door. And so we know this person let himself in. Why didn't that objective fact give a reason for the officer at that moment to think he was an occupant?
Well, Your Honor, I think that, number one, there was nothing to show on this record. In fact, we just have a statement in passing after the fact that he said, oh, I live here, and that's when the officers learned that information. They did not make the presumption that he was an occupant when he walked in that door. I could tell you just from personal experience, my sister has my key. That doesn't make her an occupant of my home. It just makes her somebody who knows how to unlock the door.
It may not make her factually an occupant, but we're talking about reasonable suspicion, right? We're talking about something that's less than probable cause, aren't we? Isn't it a reasonable inference when someone lets themselves in through a locked door that they have some sort of access to the premises and might well be an occupant?
I suppose it could be an inference that could be made, but it wasn't an inference that the judge below here made out of the facts that she had before her, for one thing. And I would also say they didn't make that same inference in Sousa, where somebody walked through the door. We don't know whether or not that door was locked, I don't think, but we can't make that assumption. I think, I think the bigger question here, and I appreciate your point, is he an occupant or is he not an occupant? If you decide he's an occupant, then that's just an easy question. If you decide he is not an occupant, then the question becomes, is this...
I'd like to explore that, and I'm going to give you the dreaded hypothetical. Police are doing a drug warrant, and they come in and they see in the place they're searching 2 people in addition to the occupant who are there, and they know for a fact are the drug dealing gang buddies but do not live there. Do they have to just let them wander around while they do the search? I mean, obviously not. What can they do in that circumstance?
That's actually a very good question, Your Honor. It's obviously not the fact pattern that we have here. I think what I wanted to say about Michigan versus Summers at the end of this is that there are 3 principles that apply to occupants, that only one of those would apply to other people, and that's the officer safety issue. And what you're describing is an officer safety.
And the orderly search, control of the premises.
But if a person's not an occupant, then the orderly search issue.
They're there. It's going to be hard to do the search if you have people wandering around that you can't detain.
I think that the orderly search issue that they are bringing up in Michigan versus Summers is to have somebody directing them to where things would be located.
But yes, you're right. I do think that is what they say, and it's sort of 4 pieces to Michigan against Summers. But the second piece has to do with, mention specifically the concern that they might destroy evidence.
Well, but
and
again,
the fact that these folks have a key to the house and they just walked in, isn't that an indication that they may have some knowledge about where things are? You're not going to let them just walk around, are you?
Well, Your Honor, this is where I want to get back to. I think that Justice Ditkoff's question goes to a different question, which is police safety and maybe making things organized. And I think if you analyze this, not under Michigan versus Summers, but just under an officer safety issue, narrow focus, it is obvious that when police officers walk into an uncontrolled situation with unexpected people, when they are walking into that they have the right to protect themselves. What we have here is a different situation, and the reason why I am focusing on that is because what Sousa says is when you have a search warrant, the onus is on the police officers. They have the ability to take a step back and protect themselves and to protect a presumptively innocent person from having their person seized or searched by posting people outside the door. And that is the biggest difference here from somebody who they unexpectedly come on the scene inside.
So because they failed to post someone outside the door, they have to incur the risk that the person is now inside the door and may have a weapon.
And it gets suppressed, Your Honor.
Is that good law? I mean, is that a good rule?
It is the law under Sousa, Your Honor.
What if Sousa wasn't a Michigan versus Summers case, isn't even cited once in there. What if there's a house with 4 exits? Are the police constitutionally required to bring in another 8 officers to guard every single entrance?
I would say under Sousa, the answer to that is yes.
But where in Sousa
does it say that? Because the passage I assume you're referring to comes after the holding.
where
Judge Link
was essentially saying, well, this doesn't put the police in a bind because they could have posted somebody outside. She's not saying we rule for the defendant because the police didn't.
But I think that is the reason they ruled for the defendant, because once they got rid of the ability to search any person present and that person was actually searched, the case turned on whether the police could seize and search the person who had entered the house. And what Judge Link was saying was, if they never entered the house, then we wouldn't even be here. So I think that is all part of how that holding came across.
What do we do with the fact that the record indicates, or at least
suggests, that in fact they had someone posted outside, but then for reasons not explained on the record,
they apparently left?
Well, I think that is, again, the onus being placed on the police.
Before I read Cantanzaro, and I just read Michigan versus Summers, I would have said occupant means the people who are in there. Because it's a weird thing that the police come in and they find some people in a place they're going to search, and whether they can detain them, they have to then figure out whether they live there or not. That seems like a weird way to conduct a search.
If I may be honest, Your Honor, in the federal law, the way the federal law has interpreted the word occupant, which is different than Massachusetts, they've extended it to all persons. So they have done exactly what you have said under federal law. But that is not the way that Massachusetts has done it. That is not the definition of occupant in Massachusetts.
And the case you rely on for that is?
Oh, I'm sorry, Your Honor. I had done the research. There are a number of circuit court cases that said that. I could provide those to you.
No,
if you'd
the
like.
other way around. The
Oh,
case you rely on in
98-2
Massachusetts for saying that it's not, as Justice Ditkoff
I
says,
have the definition
everyone
in my
the
brief, Your
house.
Honor. It is Matty number 2, I believe, in Marianne Moore's Healthcare Center, defined occupant.
It's really extremely helpful, although the fact the feds do it might suggest the second floor will do the exact opposite.
Yeah, so.
I
see
want to
I'm-
make sure you get to your, what you wanted to argue, so please.
Where I wanted to go with the issue on the Frisk, though, Your Honors, is that we have a situation where all the Commonwealth has proven is that Mr. Burt was under suspicion. That's all they proved. And they had spent a half an hour with him finding things, so let him leave. So presumably they found what they needed to find. Any weapons that were found in that place were found in a safe in his room. So already we have a situation where we have much less, we don't have the idea here that this is a place of danger necessarily for the police that could be imputed.
Isn't the context here very different from Karen K?
In the following sense. In Karen K, the juvenile was apparently at her residence, outside her residence, walking. That's it. Here,
You have a fairly,
inherently charged situation where there's a search warrant being executed. They found not only drugs, but I believe a number of weapons.
In a safe.
And albeit in the safe, and then someone shows up out of the blue, and in the context of
the immediate detainment of him and his
hands, they feel a hard object at his waist. In that context, why doesn't that give a grounds for the frisk?
Well, again, there is no reasonable suspicion that is falling on him. That is also different from Karen K. The issue in Karen K was whether there was reasonable suspicion that she was involved in the crime in the first place and not just about the frisk. This is solely about the particularity about whether he himself is armed and dangerous. But because there isn't a tie between him and any criminality, there isn't a tie between...
There is if he's an
Occupant, isn't it?
Well, no, Your Honor. That, I think, is the other point. If he was, the wife of Mr. Burt, that doesn't give him a tie to being a person who would be suspected of being a drug dealer and incidentally, the police officer never said that drug dealers and guns go hand in hand. That was his burden to do under, I believe, Mazza. But I'm sorry, Your Honors. But between that, if he was an occupant, just because somebody else has that falling on them doesn't mean it falls on him. I would also say to you that the fact that there's a hard object, I'm sorry, Your Honor.
No, that's okay. I have one comment, because I'd be interested in what you might say to it, which is that the judge is the one, in her order, who says the warrant was obtained after a lengthy drug investigation into Tony Burt, Parham's brother-in-law, who was selling crack cocaine from the premises. That's in her memorandum and order, with a footnote. I have held that there was probable cause for the issuance of that warrant. And she cites a memorandum that she wrote. Now, hasn't she sort of incorporated into this case that evidence so that we can and should take a look at what was known about why they were in the building and what they knew as a result of being in the building?
That may be true, but again, the warrant was not for any person present. And the warrant, and I think that is really where this changes
but
because...
that is true. I'll take that. That's really... I want to look at the search warrant affidavit because I think it's relevant to what this officer had in his head when somebody walked through a locked door into that building. Is it relevant or not?
With your permission, Your Honor, I believe I can provide it to you. I believe I have a copy of it. that I received from the court, from the district court, not from some other court. But that is basically all, those are the situations. The only other thing I wanted to emphasize is that it is a hard object. When we have other cases with hard objects, there was already reasonable suspicion to believe that they were armed and dangerous. The fact that there was at most a very quick glance to feel a hard object is not the same thing as saying, oh, I believe this person is armed and dangerous, and now I feel a hard object. That timing makes a very large difference. I'm sorry I have gone over, Your Honors.
No, you were invited to. With that, we're going to have to turn to the Commonwealth. Thank you.
Thank you, Your Honor.
Counsel, why don't we start with
The line that
Judge Englander was going down in terms of the search warrant affidavit in the other case? Because unlike my colleague, I'm not so sure we can look at evidence in another case, even if the judge was aware of it.
Let me, first, good morning, Your Honor, and may it please the Court. It's Andrew Doherty for the Commonwealth. I just wanted to acknowledge and appreciate the work of Emma Santos, who was a law student who contributed and worked hard on this brief.
Where is she?
She is currently in the juvenile court and is doing very well there. Your Honor, with respect to the missing search warrant affidavit, I'm not sure that it's relevant to determining what needs to be determined here, because there was evidence that Officer Stanton was there to executing a search warrant for guns and drugs, and that guns and drugs were recovered. And there's also evidence that this defendant was not, he testified he didn't know who he was. He did not appear to be somebody who he knew to have lived at the house.
Suppose the warrant said you're really only focused on Bert because everything that happens is in that back room.
Sure.
Wouldn't that be relevant?
To an extent, but I think
I imagine that's not what the warrant affidavit said.
I have no problem bringing it to the court, and there's no question that Judge Squires-Lee was aware of it. I believe that was directly the subject of the hearing that had happened immediately prior. I don't know that I don't know whether it's appropriate or part of this particular record, though it was referenced by the court and known to the court. I honestly don't know the answer to that question, but I don't know that it is relevant.
You understand my question? See,
I do.
Which you didn't answer.
Well,
it doesn't the context in which the officer was operating matter? Someone walks through a locked door. You're arguing that the circumstances were such that it was appropriate for him to take immediate control of that person who walked through the locked door.
Correct.
Doesn't the context of what the officer knew about the house, about the occupants of the house, about why they were in the house, what they were looking for in the house, doesn't that matter to this analysis?
To some extent, but I just don't, so I would say it is relevant, but it is unnecessary to determine.
Okay, I understand that.
Okay. So the first question, we'll talk about Michigan v. Summers, and we're in an extraordinarily unique situation. There is no directly relevant case law here, but you do have, I guess, an overarching theme that runs from Michigan v. Summers, Catanzaro, Charos, et cetera, that talks about the execution of search warrants being an exceptional event and one that is laden with potential for anything from damage to the evidence that's being sought or danger to safety, not just to the officers, but to others. And that because it is an exceptional moment, and I think they call it a transaction, that there is I guess a looser analysis of a police officer's detention of an individual. I don't know of any cases that speak directly to where an officer's safety and the safety of others was dealt with directly. Rather, it's just continually mentioned throughout these cases.
Well,
but
can you speak about Sousa? Because
the defendant is correct that as just a matter of fact,
it bears a lot of similarities.
It does, and I think Judge Lank's language in there is dicta, in that it is not it is in addition to the holding that's central to that case. But I would also respectfully say to the court that it is dicta that is not supported by the authority to which it relies, which is Commonwealth v. Snow, where, and I just ask the court to look at the language that the Sousa opinion relies on to make this statement that my sister is relying on, and several attorneys since have relied on. I can say that there is no appellate case that I can find that relies on Sousa for the proposition that the defendant is relying on, but I do not believe that it is central to the holding, number one, and number two, that it is a statement that is well supported by the authority described in Snow. In Snow, it talks about how there were numerous officers, I think at a barber shop, and they were concerned for safety, and that officers should be concerned about safety. I think it's not cited in my brief. I can give you the citation.
Can I just point out that in
His testimony, the arresting officer says, and I'm paraphrasing because I don't have it right in front of me, that we have officers outside to prevent exactly this sort of thing from happening.
Correct, and they locked the door.
And we don't know why the second officer left.
Why the two officers left. He speculates that it was to bring Mr. Burt, that was the target of the search warrant, to the police station having been arrested.
Why do you need two police cars to take one defendant to?
I don't know the answer to that. I think Detective Stant was just
speculating. They could have been called to another. They could have been gunshots down the street. We have no idea why they're not there.
Correct, and this is I don't know if it's an exigent circumstance, but it is a bizarre circumstance. It's the only time that it's happened in Detective Stanton's 30-year career that a stranger enters an area that is being searched. And so it sort of speaks to the unique circumstances of this case and why there is no direct precedent to it.
If instead of opening the door with apparently with his key,
he had knocked on the door.
Different circumstance?
Much different circumstance, right? Because he's outside of the area of control, right? I mean, he's outside of an area, he is not in any way interfering with the safety or sanctity of the area that's being searched.
So you would agree then that if he had knocked on the door, the officer could not have done what he did here. He could not have taken control of his hands. He could not. He would have had to say, "Hey, we're executing a search warrant. See you later."
Correct. There's no reason whatsoever.
Or presumably, the police would have said, "Who are you? What are you doing here?"
Beat it, we're in the middle of a search warrant, right? I mean, there was no purpose other than, and when you sort of look at Detective Stanton's testimony and statements, he's clearly concerned about his safety, not just for himself, but also this stranger in the house. And I think it is worth sort of itemizing exactly.
How do we know he's concerned about safety? Because he didn't directly speak to that in his testimony.
He didn't, but what you see is he announces that there's a visitor in the house. We have visitors. He describes it as, I closed the distance and took control of his hands, right? And then what he does is he brings him back towards the kitchen area, and you can see this on the video. He is now controlling him, bringing him back to the kitchen area because he is alone in this house and he is in plain clothes. He's alone on the first floor. All the other officers that are there are on the second floor, and the kitchen is where the stairs are. So he's bringing him back to the area where the other officers are going to be there. He then tells the defendant, I'm just going to take your hands until other officers arrive. That's on his page 19. I'm just going to control your hands until other officers get down here. So there's a safety aspect it seems like the most reasonable conclusion.
I'll tell you, I've watched the video maybe 10 times, and I don't see how he could have felt a hard object on the guy's waist.
So we don't know when he felt the hard object, other than it was prior to
It seemed like your predecessor was walking him through the video at the time of the testimony. Maybe I'm misreading that.
I'll say it is not clear. The judge found that there was a sequence of events that his hand brushed and what he testifies to is the back of his hand brushed a hard object in his waistband.
He does speak to when he felt it, I believe, when, he took his hands down to the waist. And like Judge Ditkoff, I'm having a hard time seeing that in the video.
Right, well, you don't see the entirety of the interaction. By the end of that video, they've moved into the kitchen area, which is where, at least based on the photographs, it looks like the
Would you
the path
agree
has
that it
occurred.
doesn't show? The video does not show him having contact with his waist.
Correct, I
Okay.
do, but that doesn't necessarily mean that he didn't have contact with his waist, just that it's not
Is
depicted in the
Justice
video.
Ditkoff correct that in your view, that in the hearing, the officer was testifying based on what he was looking at in the video, that he had contact with it?
I do, but where the judge
That's
found...
odd.
Right, so I'm not sure how best to answer that, other than to say there's no clear error that the judge made in finding that there was a sequence of events where his hand brushed. I'm not sure I have much more. Clearly, his hands
I understand
are
that point.
moving that
I
way
understand that
and bringing them back.
Yeah, we have a very specific finding by the judge. There's no ambiguity, the judge's finding.
Correct. But again, just to sort of recognize the variety of potential peril that's involved during the execution, as this gentleman opens the door and enters the apartment. Number one, it's a search warrant in a home. Put aside the guns and drugs that were recovered there for a second. A plainclothes police officer is alone in an apartment that is not his. He is a stranger in a strange land, and an individual enters the apartment. And let's look at the defendant's perspective for a moment. Here is an individual who he does not know, who is shocked to see. Right, he's described as having a 10,000-yard stare on. Now confronted with this stranger in a home that he has just entered. That's part one. Then it's a search warrant for guns and drugs have been recovered. So indeed, there are guns and drugs recovered in this apartment. And then we do have testimony that he was moving his hand from the door handle to his waist. Now,
Which the judge...
Seem not to credit.
I disagree. What the judge says is that it's not depicted on the video, and as the officer testified, he was blocking that portion of it. You do see the defendant's hand is no longer on the doorknob in the video, and that's as best as I can say. But I do not think the judge is discrediting the officer.
How would you distinguish Souza? How do you distinguish Souza?
So first, I would say the relevance of Souza is that the first thing I would say is that in Souza, I believe it was a stranger entering an apartment where there was an all persons present warrant allowed.
There was. Sorry?
An all persons present.
Oh, okay.
warrant.
Yeah, she was dealing with the all persons present, so she was looking at it that way. But it's a similar situation in the holding of the court is that they didn't have any, this person is in the room during a search warrant execution, and the court didn't have the basis to pat Frisk.
But I believe also in Souza, she rejected the concept that officer safety was relevant, and if they were really that concerned.
I mean, is one way to distinguish Souza that it's ignoring Michigan against Summers?
I think that number one, yes, but.
Is it ignoring Michigan versus Summers, or just saying he was an occupant?
I think it's.
So he's not an occupant?
Correct, he's not an occupant, but only.
Part of the reason I say it's ignored is I don't see it cited.
Right, because because.
Which is odd,
She sort of
because
deftly-
that's the controlling Supreme Court precedent on when somebody enters in a search warrant.
So let me say this, the problem with Souza, right, or the difference between Souza is searched not because of a safety issue, right, but because, and the argument isn't that there's reasonable suspicion that he was armed and dangerous. The basis for the search was because he was he was present, even though he was, an uninvited guest. Now, what matters here, and what I would say is that Michigan v. Summers doesn't stand for the proposition that you can search everybody who shows up who is present at a location. That's not what Michigan v. Summers says. It says you can detain them, which was that it is not unreasonable and is not considered what we would consider to be an arrest.
I agree. That's exactly what it says.
So once we get there, the reason why this defendant was searched was not because of the inherent power of the search warrant, it was because there was reasonable suspicion that he was armed and dangerous once they felt that hard object.
I want to go back to the interchange you had with Judge Englander about 5 minutes ago.
Are you talking about what the video
Shows and doesn't show.
And
You seem to make a concession that the video does not show the officer grabbing his hands and placing them
in the midsection
of the defendant. And first, is that correct? But second, are you saying that the video doesn't show it?
or are you saying that the video
Contradicts it? Because that distinction is very important.
I think that absolutely the video does not contradict his testimony.
You're saying when the hands are kind of
a little bit out of view, it is
possible
that they did at that moment brush
as opposed to later.
Or that event happened as they were off camera, right? I mean, I agree that...
No, but there are two, in a sense, two off cameras. One is where the back of the officer is
kind of blocking the view.
And the other is when he takes him back in the kitchen. And those are two very different moments.
Correct, and we don't have video of anything but the movement towards the kitchen where the ultimate search took place.
As I understand it, the claim is that it was during the first interaction that he brushed.
No, I'm not sure that it is that clear. I can say that the judge's findings were that the sequence of events was grabbing hands, moved them down. It felt a brush. Now that moving down, it could have compassed the 15 seconds that it takes to move to the door, to then move off camera, to then to the kitchen, where he felt the hard object. But it is not immediately apparent on the video whether feeling the hard object.
Are there any cases that explain, and I should have asked your opponent this, but what are they supposed to do if they don't take control of that person? I mean, they're engaged in a search warrant execution. Are they supposed to shoo them out of the house and risk the fact that they're going to come storming back in? What are they supposed to do?
What they're supposed to do is act reasonably and proportional to the situation as it's presented, right? And if this was a delivery person wearing GoDash or whatever it is, Uber Eats uniform, and has a pizza on their hand and just happens to open a door, I'm not sure that what occurred here would be reasonable. But where it is somebody who is unknown who has a key, I think we're in a different situation. Thank you very much, Your Honor.
Just an observation. I was very pleased to see compliance with the conditional plea rule. We don't often see that, but it was followed to the letter here. And you should thank your predecessors.
Thank you very much.
Thank you both very much. The case is submitted. Our next case is 2022 P264, Commonwealth versus a juvenile. And given the context of this case, we urge the parties to adhere to not using the name of the juvenile. Welcome back, counsel.
Thank you.
Oh, you got two of them.
Yes, Your Honor. Similar issues, too.
Lucky you.
I know. Sam Renaud for the juvenile. Your Honors, with your permission, at this time I would like to spend a moment at the end just to discuss whether this case decision could be expedited before January 24th. But before that, I would like to start just from the very beginning here what the standard is. The Commonwealth on page 7 of its brief perhaps mistakenly indicates that the exit order would just be allowed for police safety. That is obviously not the case. Manaus doesn't allow that. The court rejected that in Narcisse when it rejected Fraser. there has to be some kind of predicate event, that there has to be reasonable suspicion, maybe community caretaking, maybe a traffic event. In this case, it was reasonable suspicion. So we really do have to find out, before you can even consider the officer safety issue, whether or not there was, in fact, reasonable suspicion. And that is based on the standard set forth in Lopes, which has two different distinct prongs. The
Standards
first,
of?
Lopes, the standard from Lopes. And the prongs, and this was, I'm sorry, put in, this was not my brief. I mean, it's obviously the juvenile's brief, but I did not write this, but it is in the brief. And it states that the first is that there are indicia of reliability on the dispatch, and the second is that there is particularity. Now, obviously—
That's a probable cause standard. Lopes says explicitly that it is a relaxed standard when we're talking about reasonable suspicion. How that's applied has bedeviled me through several cases over the last several years, but it is not a probable cause case, right?
This is not, and honestly, Your Honor, in Lopes, I believe that was also reasonable suspicion. DePina was a reasonable suspicion case.
Yes, but Lopes says explicitly that Aguilar-Spinelli is relaxed in the context of reasonable suspicion.
While it may be relaxed, that's a quantum of evidence. It's not the fact that the standard doesn't have to be met in the first place, Your Honor.
I disagree. That is not the way I read it. But okay, we can go forward.
I would say that there are a number of cases out there that have talked in the reasonable suspicion context, citing to Lopes, and have talked about whether or not there is in fact reasonable suspicion. Indicia of reliability. The problem with this dispatch is that, and I'm going to ask Your Honors to take the facts for this in the light most favorable to the Commonwealth, because the judge didn't make any explicit findings. Isaiah I says that if the facts are undisputed, you can accept them, and I'm not saying they're undisputed for everything, but in this case, just to expedite the argument.
Before we go there,
Yes.
surely in response to the shots fired, or possible shots fired, however you want to characterize it, there is no problem with the officer going to the scene. Can we agree on that?
Yes, Your Honor, we can
And
agree
there's
on
no
that.
problem with him going to the back parking lot of this particular enterprise, given that's where the shots reportedly may have been fired.
Exactly, Your Honor. But that's the whole point here, though, which has to do with corroboration.
Okay, but if the officer then, in this context, at either midnight or 1 in the morning, sees a carload full of people parked in the parking lot of a closed business, I mean, forget the shots fired. Can't the officer go up and say, what's going on?
If he had done that, that would certainly be the case, which is what it appears happened with the other couple that Officer Morris had gone up to. It appears that they went up to him and say, did you hear a gunshot? And they didn't, and they said, no, we did not hear a gunshot.
Okay, and you kind of glide over one issue, which is, you say this is a car stop case. Where was the stop? The car was stopped.
Well, it would be, I suppose you could look at it either as a car stop or you could look at it as a seizure of individuals. And the same principles apply to both. DePina was a case where it applied to individuals, and Lopes was one where it applied to a car.
Was there a seizure before the exit order?
I think, I don't believe so, Your Honor. I think that when they gave the exit order, that was the moment of the seizure. Because up until then, there had been some discussion on the record about whether or not these juveniles could have driven off and that they didn't drive off. There was no way to stop them. He didn't appear to have opened one of the doors. He didn't, do anything.
At what point did the second officer come on the scene? Because as I understand the record, it was the second officer who observed the open containers in the...
They were not open, Your Honor. They said, I saw 2 alcoholic containers. And we don't have any ages of these individuals. So I just want to make sure that that is clear. It appears that the other officer came on the scene, from what I could glean from the record, that the first officer was examining the car area, Officer Green, for about 5 minutes in that area. At the same time, Officer Morse was interrogating the people who said that the people involved in the fight had fled in the opposite direction and that they did not hear a gunshot. Officer Filowick was looking at some garbage or some other items, and he saw Officer Morse talking to them. At that point is when he went over to assist with the exit order. So there was already information from fellow officers that had been gathered before he even went over there. So the only thing the thing that was driving this was not the observation of the marijuana. It was not the observation of the alcohol. The alcohol was not thought to be open in the car. At least that's not the testimony. The marijuana was in bags, and we know from Cruz that, smelling marijuana wouldn't be justification. Certainly we have a juvenile here, but nobody testified to the apparent age of any of the people who were in this vehicle or what their actual ages were. So they were not suspected of being under arrest. The entire driver of this was this alleged...
I'm sorry to pause you there, because you're right, it's not been briefed, and we probably shouldn't spend a lot of time on it, but it turns out that the person was a juvenile. We know that because we know the caption of the case. Is there any inference available that the officers had reason to believe that something was up because there was marijuana in the car and the people looked young?
I don't think so. That certainly the Commonwealth had that burden to establish that, and they did not.
Okay,
and
all right.
I would also
Okay.
say that nobody saw them actually smoking anything. It was just he smelled the smell of burnt marijuana, which could have happened at any particular time.
I'm sorry to interrupt your argument.
No,
because I
I'm
think
sorry,
it's
Your
a
Honor.
sideshow.
So this is, I think just getting back to this, there is a corroboration element that is necessary, I think, for when you have an anonymous, and this person was fairly anonymous. They, when Officer Filowitz was asked about this person, he said, "I don't know who it was." The prosecutor said this person wasn't anonymous, and he said,
Was this argument made below?
It was. In fact,
How was it made?
the Commonwealth developed this record, Your Honor. The Commonwealth itself asked those questions. The Commonwealth argued this point in the court below. So even if...
My understanding of the record is it wasn't raised by the defense. The Commonwealth addressed it in their evidence. Am I right?
The Commonwealth addressed it in their evidence and in their argument, Your Honor.
But the defense did not raise it. They did not say one of the reasons why this should be suppressed is because there was inadequate information regarding gunshots or anything else given the nature of the tip. That argument was not made.
You are correct, Your Honor. However, this
Okay.
is the law, and on top of which it wasn't the
Whether
defendant's...
it's the law or not, what do we do with that? Is
I-
this a substantial risk of a miscarriage of justice case?
I don't believe so. It's the Commonwealth's burden. So if there is a legal issue on which the Commonwealth failed to establish their burden, that issue can be decided regardless of whether the defense
argument
raised
has
it.
to be made. It's your motion. Maybe I'm wrong, but
The judge below should have addressed this. I mean, this is an...
the judge has to do it sua sponte. That it's not the defense's job to say, here are the reasons why it should be suppressed, because there was an inadequate tip and inadequate information for them to take the children, take the occupants out of the car.
Your Honor, the judge is supposed to apply the law as it is, and
They have
at
to be
least
pointed
cite
to what the
Lobes.
problems are. That's the whole concept of waiver. That's what I'm trying to get at. You're saying to me, no. I've never seen a case that says what you say.
I think my point is that it was the Commonwealth did not waive the issue. And because it was the Commonwealth's burden, it still should have been addressed by some court. And I think that is the point. It wasn't the defendant's job to establish the contours of the argument. It was the Commonwealth's job because it was their burden. At least that would be my position on
Once the
it.
defense says you should suppress the evidence, it's the Commonwealth's burden to do what?
To marshal sufficient evidence to make out reasonable suspicion. And as the law says, that they had two places where they had to make out reasonable suspicion. One in whether or not the dispatch had sufficient reliability, and the second is whether or not there was sufficient particularity once they were actually at the scene.
Yeah, can I, speaking only for myself, I'm having a hard time seeing why these issues aren't largely a red herring. What do I mean by that? It seems like you have much stronger arguments that, the reports are, there's a fight going on, people are running away. These four guys were sitting in a car.
Well, that was actually the
That
next
seems a lot stronger than arguing about whether the shots fired
Yes.
message was reliable.
Thank you, Your Honor. I actually do agree with that. It's just that this was an issue that was not presented in the briefs. But I think on that point, if you look at the Ducey factors and you look at them individually, there was literally one factor here that weighed potentially in favor of reasonable suspicion. And we know from other cases, we know from other cases that, I'm sorry, I lost my place, Your Honor, that having only one basis for finding for particularity is almost never enough. And in the case of this, when you look at these gun cases, and you talk about proximity, you're always talking about a quarter mile away, a half a mile away, because a gun case is loud. It's not like a stabbing. It's not like something else. It's something where when somebody is likely to call the police, the people are likely to flee. So proximity is about somebody being a little bit ways away, not sitting in a car with
They're
further
too
buddies.
proximate? Is that this argument?
Well, I'm talking about the inference that you can draw from proximity here, the idea that somebody would just be sitting in a car, not doing anything, and when they see an officer and had the opportunity to leave, they didn't leave. You know, he hadn't stopped them yet. They could have left. If they had been, the inference that you can draw from this is that if there was in fact a gunshot, which we're not even certain about, in this back parking lot, 5 minutes later, those same people would still be sitting there. That seems highly unlikely. But when you look at all the other factors, there aren't any other factors. We don't have any description of the alleged perpetrators, not their race, not their number, not their clothes, not anything. And that has always been the first among equals. Warren says, you look for the description because you try to figure out who it is, even if it is a general description. We have nothing here. We have absolutely nothing except for this proximity
I'm going to
issue.
ask you the question. By the way, having to argue two of these in a row, you're doing fabulous, okay? But I'm going to ask you the question now that I should have asked you in the last case. What would you have the officers do? They get a call about a possible gunshot at a specific location. Within minutes, they arrive at the specific location and they see 4 people sitting in a car exactly where it happened. What are they supposed to do?
Exactly what they did to the other couple. Knock on the window and say, hey, I've got a couple of questions. Did you hear a gunshot? And see how people reacted.
So, but before they did that, the evidence is they said, get your hands where I can see them. Mm-hmm. That's okay, right? That's not a seizure?
Oh, actually, that...
Because I'll tell you this, if you tell me they couldn't say, get your hands where I can see them, I'll tell you that doesn't sound like anything that I wouldn't think is reasonable.
That is actually a seizure. I'm sorry, Your Honor. I think
that's a seizure.
I think that would be a seizure at that point.
But how can that be an unreasonable seizure under the circumstances?
Because we don't have a public safety exception, Your Honor. Just because there's a gun involved doesn't make it a public safety exception. You have to still have reasonable suspicion.
They have reasonable suspicion. Don't they have reasonable suspicion a crime has been committed because they heard that a gun was fired?
They do not, especially at that point when
the firing of a gun under those circumstances, 12:30 at night, potentially outside, isn't that a crime, just period?
The dispatch said there was a bang. When they went to 2 people who were on the scene, those people denied that they had heard a gunshot. At this point, reasonable suspicion is lowering. It is not increasing. This is not Evelyn where you see a victim.
It's a pretty low bar, isn't it? I mean, the police have to investigate it.
It's not a bar that doesn't exist, however.
Had the couple interview happened before had it happened before the protective sweep?
From my reading of the transcript, it did, because it sounded like the third officer had seen Officer Morse talking to the couple before he went over to the car. And so that all would have happened prior to that. So timing-wise, they already had dispelled some of the suspicion. If I may just very, very briefly, this is a case on interlocutory appeal. There was not, the case wasn't prosecuted by prior counsel in a timely manner. So we were leading to a point where the juvenile is aging out, and he is going to be suffering from the consequences of this potentially, of having
and
his anonymity.
February 28th?
No, that's a birth date, Your Honor. This is January 24th is the next date where the Commonwealth apparently is going to make a decision about whether to find him to be a youthful offender. We just ask that you either issue a decision, if not the full, an order, if not the full decision prior to that date, just so that there's some clarity and that he doesn't fall within the cracks of potentially having, all of those consequences of not being a delinquency adjudication any longer. With that, I would just rest on the briefs. Thank Thank you, Your Honors.
Thank you, counsel. We'll hear from the Commonwealth.
Good morning. May it please the Court. Danielle Borges on behalf of the Commonwealth. The Commonwealth respectfully asks this Court to affirm the motion judge's decision to deny the juvenile's motion to suppress, where the motion judge properly concluded that the exit order, pat frisk of the occupants, and protective sweep of the vehicle were lawful. Initially, I would like to address a citation error on page 8 of the Commonwealth's brief. The entire second paragraph, starting with a protective sweep, should be citing Commonwealth v. Johnson, 82 Mass Appeals Court 336. That was an error that was brought up in the juvenile's reply brief, so I just want to address it and correct it on the record. And
Can we,
apologize.
that's fine, thank you. I'm troubled by this Aguilar-Spinelli relaxed standard, whatever it is. Justice Milkey's less troubled, but don't you have a problem?
In terms of whether there was reasonable suspicion,
Yeah.
I would argue
Based
no.
on what turns out to be, or what one might well characterize as an anonymous tip?
So first, I would argue that whether it's anonymous it's disputed, because in Officer Morse's testimony, he initially said it wasn't an anonymous call. It wasn't me who went further to identify the caller.
His testimony, although there's no objection, is at best hearsay.
Yes, but initially there was also, I believe it was Officer Morse who also testified that there was a shot spotter activation. So I think we have the 911 call, which we discussed earlier. The police would have to respond. They can't just...
So we should take that testimony because there's two different officers, you're right, and the second officer says it was a shot spotter activation.
Yes.
Or I don't think he uses the word activation.
I
It says
think...
like something like a shot spotter call. Since there's no objection to that, that's sufficient evidence to indicate corroboration to the tip.
I would say yes. I would say the activation...
Interesting.
Which I
Okay.
think it was on page 23 of the motion trial transcript. I do think he said shot spotter
He does,
activation.
yeah. I don't know what, well, all right,
Yeah, he says activation.
okay.
So I think when you have those two things together, it does corroborate the 911 call. And then once they respond to the call, I think there are numerous other factors that weren't discussed previously that did justify the exit order. And then once the exit order is justified, responding for a call for gunshots.
Before we get to the exit order,
From the Commonwealth's perspective, when did the stop occur?
I would agree with what was said before. The stop occurred once the police officer, I believe it was Officer Green, approached the car, flashed the flashlight, put your hands up. I mean, I don't think a reasonable person in that position would believe that they were free to leave, given those situations, given the facts.
Okay, and at that point in time, other than that these individuals were near the location where a possible shot had been fired, what provided reasonable suspicion to believe that they were involved in the shooting when the calls are about people fighting, people running? These four guys are sitting in their car.
Sure. So it was the exact proximity. The call was for 1200 Main Street. They were in the parking lot of 1200 Main Street. 12:30, midnight, the businesses were closed. They were there in the car. The officers were responding to that area with the knowledge that there had been an uptick in gun violence in that specific southwest sector of the city previous weeks. So I think that also contributes to the reasonable suspicion. Anytime you're responding to a call for gunshots, I think there's a heightened sense of danger. We can all agree to that. That's another thing that leads and supports the officers' concerns for reasonable suspicion. Proximity in time, physical location. The officers testified it had been mere minutes since the call that they were able to respond to that location. Not that this alone is enough, but the officer did say when he flashed his lights, all four individuals looked terrified, startled, their eyes shot out.
I'm sure they're sitting in the car smoking marijuana and drinking
Right,
underage.
that's why that
If
alone.
you're a juvenile, you might look a little
pretty
scared
startled.
when the cop shows up.
Of course, and that alone would not be enough, but that I think plays into the totality of the circumstances that the officers are allowed to
I'm
consider.
having a hard time with that one, not only for the reasons my colleagues have expressed, but
If if you've just been involved in a shooting, you're probably not surprised the police showed up.
Possibly, and even if we strike that, even if we say, okay, don't consider the nervousness of the occupants, I still think there's plenty to contribute to the officer's reasonable suspicion. Initially, he approached the car by himself. He was outnumbered. That's why he radioed for backup. And again, the vehicle was in the direct vicinity where there had just been a call for gunshots mere minutes prior. So I think when you look at all those factors together, the Commonwealth would argue that there was no doubt that there was reasonable suspicion for the officers to order the exit order and then subsequently do the protective pat frisk of the individuals and of the car. Again, you're responding for gunshots. There's potential that there is a gun on the scene. There is a potential armed and dangerous suspect who is ready, willing, and able to fire a gun. And I think that the officers were correctly responding and ensuring
If
their
there's
safety.
no shot spotter, let's take the shot spotter out of there.
Okay.
So all he knows is someone said there was a loud bang, and I think it was a gunshot. He then arrives and he sees 4 people sitting in a car. We don't have any evidence as to the reliability of the person who said it. Is that enough to get them out of the car and do a pat frisk?
Without the shot spotter activation?
Yeah.
I would say yes still, because again, the same factors that I just listed are still present.
So that basically means, that's very blanket, that's a very aggressive position, I think. But because that's basically saying anybody who is at that location within minutes may be automatically pat frisked once there's any evidence that there was gunfire.
Well, it's also at that time, again, looking at the factors, midnight, the business is closed. There's not going to be likely a ton of people in that area at that time. They're responding for gunfire in an area of the city that had seen an uptick in this gun violence. So I think that, yes, even without the shot spotter activation.
That's a good answer.
Thank you. The officers would still be justified in ordering that.
With these occupants, might be even more suspicious if the nail salon is open.
What was that?
Might be even more suspicious the nail salon is open. I don't think they're going to the nail salon.
Oh, yes. Well, that aside, is the fact that it was a closed business parking lot, 12:30. Yeah, and if there are no further questions, based upon the foregoing, the Commonwealth would ask that this court would affirm the motion judge's decision to deny the motion to suppress, and the Commonwealth would rest on its brief.
Just any light, can you shed any light with regard to the expedition issues and the importance of whatever January hearing date we're talking about?
Sure. So that is in the realm of the juvenile unit in my office. I haven't been given any insight on whether they plan to move forward. I know that what was brought up earlier has been discussed, but I'm not in a position to say whether that's still their plan. I could certainly go back and talk to them and respond
If
back.
it turns out that the juvenile unit has decided they're not going to indict no matter what happens, please let us know that.
Absolutely.
Because then we don't have to expedite.
Sure.
Otherwise, we'll assume we got to do this
Okay.
as quickly as we can.
Yes, absolutely. I can do that.
It's not fair to stop this early.
Okay.
That's exactly the opposite of what Judge Milkey said at the beginning.
Yeah, but this case is hard.
So I haven't hit a home run yet, is what you're saying.
That's right. So let me ask this. What is the significance of the other officers and what they found? Is there any significance? Your opponent put in their brief what was found by the other officers. They met 2 people who were on the sidewalk. There were clothes strewn all over. There were people running. When the first officers got there, they saw people running. Is that anything that meets what is important here, given that the officer who made the stop and the frisk didn't testify about seeing any of that? Did testify he saw his fellow police officers out front interviewing someone.
So with regard to the 2 individuals that were being interviewed, I believe Officer Morse ultimately testified that they were completely unrelated to the call for gunshots. I believe his testimony was that one of the individuals had said he had just been jumped, but then did not want to speak to the police any further. I know they had stated they didn't hear gunshots, but my understanding of the testimony was that those individuals did not want to prolong their interaction with the police officers any longer. Whether they did hear gunshots, I don't know if we can trust them 100%, but they were determined to be completely unrelated to the matter.
Right, but here's the thing. In terms of corroboration, So you started with, I thought, a very interesting point, corroboration for the phone call. If one officer says it's a shot spotter, well, a shot spotter is corroboration for the gunshot, right? Another piece of corroboration might be when the first officers arrived on the scene, there were people running around, looked like they'd been fighting, right?
Yeah.
So that was part of the tip, was there were people who were fighting. Except there's nothing that tells us that Green actually was aware of what those officers had seen when they arrived. Does that matter?
I'm not sure in terms of whether it corroborates the 911 call, because again, I think at that moment, it's happening very quickly, it's escalating again. There is still, even if they didn't see any shells or see people running, they're still responding to a call for gunshots, and I think it's in the interest of their safety and the public safety to ensure that that threat is not real and active. So I think they still had to continue with what they were doing, whether they could exactly, as soon as they got there, they could see something that corroborated the 911.
Another way for them to handle this, and it is, because at the end of the day, it's just what's reasonable, right? I mean, that's what the Constitution says. So shots are fired, they go to the back, they see a car. They can walk up to that car, they can say, roll your windows down, I need to talk to you. The people in the car have the right not to talk to them, okay? But they, you know. Can they say, get your hands where I can see them?
I think, as we discussed earlier, that is a reasonable approach, especially when they're responding for
Is
gunshots.
it a seizure?
I think I would say yes, as we said before, because...
All right, so it has to have reasonable suspicion.
Right, and I think there was reasonable suspicion.
Yeah, I know you do, but I'm trying to take this one step at a time because I'm not so sure.
Okay.
But what I do know is that it's very reasonable for a police officer to respond to a report of gunshots, walk into the back of exactly where those gunshots were supposed to see, and go talk to the people who are sitting there.
Right.
Right? And when there's four of them in a car, it seems to me to be pretty reasonable that they say, before they go talk to them, get your hands where I can see them. All right. I don't know that I can go any further with this. If you have anything to shed on it, let me know.
If there are no further questions, the Commonwealth will rest on its brief, and I will discuss with the juvenile unit and see if I can respond to the court's question regarding that.
Thank you very much.
Thank
The
you.
case is submitted.
I argued two cases on a day several times, but never two cases that were this similar.
Very well done.
Our third case of the morning and the last case we will hear before the brief mid-morning break is Commonwealth versus MACLAGAN, 2022 P41.
May it please the court, Patrick Noonan for Mr. MACLAGAN. Thankfully, I only have one case to argue today. So this is a case where we're just asking that the matter be remanded back to the district court for an evidentiary hearing on the defendant's motion for new trial. The main issue that I want to concentrate on and devote my time to is the video evidence. On this case, there was an assault and battery he was charged with resulting from an incident with his wife in the parking lot of a gym. The defendant obtained a video of the gym parking lot, which completely refuted and contradicted the alleged victim's allegations as to what occurred in that parking lot. She had stated to the police that she had exited her vehicle to get away from my client, and that in the parking lot he chased her and struck her with a closed fist, tried to pry a cell phone out of her hands, and she had to shield herself from blows with her forearm. There was a video of this incident which showed that none of that even happened. There was no assault in the parking lot, no chasing.
What did counsel do that was ineffective with respect to that?
So what happened was counsel had the video, gave it to the prosecutor on the day of trial, but told the defendant essentially that this video, more likely than not, was not going to come into evidence.
That's not even what your client says in his affidavit.
So
He
what
says that it may not, is my memory.
Yes, he said that
Well, that's a big
there was a
difference.
possibility, but he had also stated at the hearing on the motion for a new trial that he told me, meaning his lawyer, that they were that they wanted to throw out the video evidence. I know the affidavit also says that there was a possibility the video wouldn't come in, but he says in the affidavit that the prosecutor did not want the video to come into evidence.
Well, the prosecutor didn't. The prosecutor was saying, I just saw this 5 minutes ago, and the way the judge handled that was to say, you know what, go take a look at the video, and then we'll figure out whether we're going to let it in or not.
And left the decision up to the prosecutor as to whether she wanted to go forward with it, but the attorney is basically representing to the defendant that there's a likelihood that this video won't come in.
That's
and if
Possibility
that it doesn't come in.
I'll read you what his affidavit says, because I'm struck by this, okay? McMahon stated that the prosecutor did not want the video to come into evidence. I think undoubtedly correct. And McMahon told me that there was a possibility that the video would not be introduced at trial. Probably also an accurate statement.
But the fact of the matter is the prosecutor was stating that I was given this video 5 minutes ago. However, the judge basically said to the prosecutor, I'm going to leave it up to you. You watch the video, prosecutor. If you want to go forward with this case, then we'll do it. But the big consideration for the defendant is, hey, if I know that this video is coming in, I'm going to go to trial on it. But if I'm being told, even if that there's a possibility that it's not going to come in, and there's an uncertainty about it, then his decision is dramatically altered. Now, there was no definitive...
So that's the ineffective assistance, is the advice that there's a possibility that it might not come in. Wasn't that advice correct, or at least within the range of what we would expect from a reasonably competent lawyer?
I don't think it was entirely correct, because there was no ruling by the judge stating this video is coming in, this video is not coming in. The judge didn't say, there's no way this video isn't, there's no way I'm not going to let the video in. The judge didn't say that. He said, prosecutor, take a look at that video. If you want to go forward with it, we'll do it. And the judge stated his practice was if, a party on a first trial date needed a continuance, he more than likely grants a continuance. So if there was any dispute as to whether this video was going to come in or not, the judge would have granted a continuance if defense counsel had requested it. The ineffectiveness comes in just in the scope of representing to...
So the only evidence we have on this subject, and I'm poking my finger where you're weakest, because there's no question in my mind, having reviewed the video, that was pretty darn good defense, okay? But the only evidence we have of the ineffective assistance that you're focused on is your client's own statements to that effect, right? McMahon told me that the case was scheduled for trial today and that there would be no continuances.
Right.
Which, if the lawyer actually said that, would have been very problematic, because there probably would have been a continuance had they sought one. But the only evidence we have of that is your client's own affidavit, right?
Sure. And that's why I think that an evidentiary hearing is appropriate. That way we have plea counsel come in and basically explain, what did you say to the client? What was the conversation, A? What was the conversation you had with him about the video? What did you say regarding whether it was going to come in or not?
When you went to the hearing, did you know the hearing was going to be a non-evidentiary hearing? The
Yes,
hearing on the motion for new trial? Judge
Yes.
said it'll be non-evidentiary?
Yes, it was by Zoom. It was not evidentiary. My mindset going into the hearing was, it's not evidentiary. I want to meet my burden of showing a substantial issue to warrant an evidentiary hearing. I didn't subpoena plea counsel. I did reach out to him, didn't receive a response back, but my mindset was make a substantial issue showing and get this case to an evidentiary hearing level. Aside from the video, the second issue I want to focus on is the issue of jail time, where, and again, this is...
I don't get this one.
Yes.
I mean, because, yes, we know that if the defendant pleads, he's not getting jail time, even if the Commonwealth gets what they want. But how does that tell us what the Commonwealth would want if the defendant doesn't plead? Presumably they're going to want higher. How do we know they don't want jail time if he goes to trial?
So that wasn't clearly stated in the sidebar when the case was first called. When the case was first called, the judge essentially said, like, well, tell me what this case is about, and asked the prosecutor, what are you looking for? And the prosecutor just says, lengthy probation with the batterers program. I agree with Your Honor, where it wasn't one of those situations where the prosecutor is saying, this is an offer pre-trial, take the probation. If you go to trial and you lose, you're going to go to jail. So I agree with you on that. The sidebar is not very lengthy, but after the sidebar, my client says that the attorney said that the prosecutor did want jail time, and that jail time was on the table.
Why would we even suspect that's not true? If the Commonwealth wants long probation on a plea, the chances that they're going to want jail time on a conviction seem pretty high, and we don't know what discussions, I know this gets back into we need an evidentiary hearing, McKenna had with the prosecutor on what would happen if there wasn't a plea.
Well, I think one thing is if, the prosecutor is stating lengthy probation, no jail time, basically gives the judge kind of a snippet of what the trial is going to entail. Based upon that, if the Commonwealth proves its case, that's the evidence that they were giving to the judge at that time, and the prosecutor can request jail time at the end of the trial. Doesn't necessarily mean that the judge is going to give the defendant jail time. But I think that if the defendant is under the impression that jail time is very likely, and that if he does a plea, he could avoid jail time.
But he doesn't even assert that in his affidavit, that he was told jail time was very likely, or that he even believed that.
He said at the new trial hearing, when my lawyer returned to me.
I'm looking at the affidavit. Can we really consider unsworn statements by the defendant at the new trial hearing?
On a non-evidentiary hearing, I say yes, because it's up to the judge to conclude whether the defendant's affidavit is credible or not. And one of the issues
And so if his unsworn statements at the new trial hearing differ from the affidavit, isn't that suggest that the affidavit isn't credible?
I don't think that they're inconsistent with each other. I think that he elaborated more fully on it when he spoke at the new trial hearing. I think that the judge can certainly look at any sort of inconsistency between the affidavit and what he said at the new trial hearing. But one of the problems that I sort of have with this case is that there were no written or oral findings, so we don't know what the judge had considered. We don't know if the judge said, the affidavits are not credible. We don't know if the judge said the attorney's decisions were reasonable and tactical. So I think that one of the reasons why this should be remanded back for an evidentiary hearing is so that we can have the benefit of a hearing and the benefit of findings on the record. But here, the Commonwealth's brief, very well written, by the way, states a lot of things about what the motion judge, could have found. These are not credible. It's not substantiated. Tactical decisions by the attorney, but we just don't know what the trial judge or the plea judge was.
Let me ask you what I'm going to ask your friend at some
dreaded
length.
hypothetical.
No, well, maybe it is a little hypothetical. We have all this case law about how a judge can disbelieve a self-serving affidavit, but usually that's in a context where there isn't an affidavit of, counsel to look at. I'd like to hear your best argument that sort of doctrine doesn't apply in a situation here where you've taken multiple steps to get an affidavit of plea counsel and through no fault of the defendant you can't.
So I think in that particular situation where efforts have been made to get the affidavit from plea counsel, I think that that is a reason for this court to say then we should have an evidentiary hearing. Because an effort was made to get that affidavit and it wasn't obtained, then I think the only alternative is to have an evidentiary hearing so that we can know what was going on with plea counsel. Otherwise, it's a very difficult decision then for the plea judge or the motion for new trial judge, because he or she is limited by what the defendant is saying in the affidavit. And
It was the same judge, right? Same judge who
Yes.
took the plea?
Trial judge was also the plea judge was also the motion.
Can I,
Judge.
as long as my colleagues don't have additional questions, I was struck by the following. Prosecutor says on page RA 332-33, here's what happened in the first assault. The court says, did you hear those facts, son? Witness, that's not true, Your Honor. And then the court says, hearing those facts and being given your rights, it's your intention to admit sufficient evidence. Is that correct? Yes, Your Honor. Whatever the heck that means. And then the second set of facts are read by the prosecutor on page 34. And the court says, hearing those facts and being given your rights, it's your intention to admit sufficient evidence. Is that correct? Witness, that's not true, Your Honor. Why are we here? I don't get it.
So
I'm not really being facetious. I don't understand how, as a matter of sort of criminal law, when we have a defendant who says, I don't agree, that we have any kind of adjudication from which there can be an issue.
he also, the defendant says something to the effect that during the plea hearing that he says, quote, there's a lot of comments. If I was going to bring this case to trial.
Let me put a finer point on what I'm saying. You didn't make this argument as I understand it. And so I'm troubled by the whole context in which this case is in front of us on a motion for new trial. He took a quaff where the judge read what was he supposedly did, and he said, that's not true, Your Honor, twice. So how can that quaff have been entered?
Well, so, you know, Your Honor is saying there's an alternative ground here because the defendant is not admitting. What I had said in my brief was that the defendant said during the plea hearing that, hey, if this case is going to go to trial, ... meaning we had this video, if it were admitted at trial,
That's
I
the
would have
next
gone
thing
to
he
trial.
says. You're talking about what he says on the next page where the judge wants to bring it to conclusion and he says, well, Judge, I just want to let you know if I'd had a chance to go to trial. And the judge then literally cuts him off,
Right.
so he can't even say the next words that were going to come out of his
Yeah,
mouth.
but I think that it's a reasonable inference to say, hey, if this case were to go to trial, I could ...
Right.
I think it's a reasonable inference to say, hey, Judge, if I had this video and if it was coming in, I'm going to trial. But the judge cut him off rightly, but I think
Cut him off rightly?
Well, at that point, yeah, I want to step back because at that point, the judge should have advised him if you're, and this happens a lot in district court, if you're not going to admit this and you're going to deny it, then I'm just going to reject the plea altogether and go have a conversation with your attorney. Here, the colloquy is, I'm essentially disputing that these allegations are true by saying if this case were to go to trial, I could. So at that point, the judge could have said, if you're not going to admit to this, we need to take this back and you need to talk to your attorney. And then another conversation with defense counsel would have been fruitful then, where the conversation could continue as to, if this video is not going to come in, then I want a continuance of the trial. So,
Counsel, thank you very much.
thank you very much, Your Honors.
It might be a good idea to start where we ended.
Certainly. Good morning. May it please the Court. Julianne Campbell on behalf of the Commonwealth, and certainly I will address Justice Englander's point to begin with. I do note that it was not raised by my brother either in the motion for new trial or his brief.
Well, I guess that leaves with two questions, right? I mean, the first one is this did this person take a quaff? I mean, is there any way that
Yes.
that you can have a proper, on this record, you
Yes.
think this is a proper finding? of
Yes,
continued without a finding?
because this defendant did not plead guilty. He pled and admitted to sufficient facts that could convict him at if the evidence were presented at trial. That's the plea, that's the tender
Doesn't he need to
plea.
know the elements to do that?
He certainly does, but there's no suggestion here that he doesn't know the
Well,
elements.
I'll suggest he doesn't, because the three ways of doing that is either him agreeing to facts, or his attorney stating on the record that he told him the elements, or the judge reading him the elements, and I didn't see any of those.
Candidly, I did not read the transcript with that in mind
That's
because
fair.
it's not briefed and before this court.
That's fair, this is a
That's the second question.
total ambush here, so.
Yeah, it is a total ambush, and we're dealing with counsel who's very experienced, and so we know that, okay? I say it's a total ambush. I mean, it's referenced in the briefs, and it sort of jumped out at this neophyte, okay? I'm really struggling with this. You're right, it's not argued this way. Does that mean we cannot address it?
Yes.
Should not address it?
Cannot, because
Cannot.
what is before this court, this is the defendant's appeal from his motion for new trial on grounds of an ineffective assistance of counsel, which were specifically outlined below, that the Commonwealth wrote in opposition to below, argued at a non-evidentiary hearing, and is now here before this court. This is not a 33E review. This is not a capital case. The defendant raised this specific issue, the Commonwealth responded, and that's what's being litigated today.
So we have to wait for the next ineffective assistance?
I would suggest so, at which point I'd be happy to be back here before your honors and argue this.
With a little more prep on
yes.
issues you didn't know were going to be raised.
Yes, thank you.
Well, that's fair, but I'll tell you, and there has been some, the notion that what he says here can then end up landing him in jail, which is what happened as I understand it, or is what is pending potentially because of his subsequent occurrence, that's very troubling.
I understand your honor's concern. I think that there is an avenue in which that this is not as troubling as your honor might consider it, but again, it's not before this court today.
All right, so let's talk about what is before the court.
Certainly. So my position is that the judge did not err in denying the defendant's motion for new trial based on what the defendant submitted to the court, because a substantial issue was not raised. And specifically, I know that my brother was asked about the lack of affidavit from plea counsel. You'll note in my brief that I don't even really reference that. And the reason is because setting that aside, which I think the Commonwealth typically relies on for arguing there's nothing to see here, this is a self-serving affidavit, the defendant's affidavit itself fails to support his claim of ineffective assistance of counsel for several reasons. One, he admits on pages 138 and 139 of his affidavit that his attorney had all of this evidence, all of it. And now, after the plea, a year after the plea virtually, days before his probation is set to expire, and 2 months after he receives a notice of violation, all of which Kerrigan says the court could have considered in assessing the credibility of his affidavit and could view as suspect. All of that, I would suggest, would lend the judge to conclude properly that there was no substantial issue
Can we
raised.
talk about the video?
Certainly.
Because that appears to be his strongest point.
Theoretically,
Advice that there's a possibility that it may not come in is,
accurate.
Right.
but is that realistic?
Yes.
here? Why?
Because first, I would point out that the defendant says he got this video himself. The video that was submitted appears to be recorded on a cell phone. Setting that aside, It's always a trial issue that an individual must authenticate a video before putting it in. If the defendant could not have done that, it may not have been in. There's no witness that was referenced as a supporting witness regarding the video itself. Aside from that, what
Well, the defendant would have had to testify, but
I apologize.
he would have had to testify to authenticate it, but I don't see why you wouldn't expect him to testify in this case.
He certainly could have, but again, this is speculation that, and where the defense attorney had the video prior to trial and apparently referenced it as early as a pretrial hearing to the Commonwealth. It strains credulity to accept that the defendant was somehow prejudiced by this. Counsel was aware of it. Whether or not to hire an expert, I'd suggest, is a tactical decision, which would not have been manifestly unreasonable here, given the state of the evidence, which was, first, the Commonwealth intended to prove at trial that the assault and battery occurred inside the car. I recognize that differs from the victim's written statement. However, that written statement the defendant had and could have been appropriate for impeachment evidence. Second,
But I don't know how that helps you. I mean, I think...
if counsel had it and was aware of it, and there is nothing on the record that suggests he was unprepared to use it.
I understand that point. I just lost you on the sort of the note. I thought you were going to suggest that there was, it seemed to me that you were suggesting that the defense's evidence with respect to this particular event was weak.
No,
for
that's not
some
my,
reason.
no,
The defense's evidence is extremely strong as I look
I'm
at
not what I'm saying is the defendant had the video.
Yeah.
And whether or not to call an expert, I would suggest would have been fruitless, but in any event was not a manifestly
You're saying, what did the lawyer do wrong? Which is
Yes.
kind of the question that I started with.
Correct.
But can we go back? Because there is an answer to that,
Sure.
and I'd like you to address it. So in the affidavit, and we don't have an evidentiary hearing, he says three things. He says, the lawyer told me, one, there was a possibility the video would not be introduced at trial. Two, that the case was going to go to trial today and there would be no continuances. And three, the prosecutor wanted jail time. Now, is that enough? Is that enough for someone to conclude that there was ineffective assistance of counsel leading him to plea when he shouldn't?
I'm sorry, I just want to make sure that I have the three in order. So I have the no continuances, the jail time.
Number one is, there's a possibility the video would not be introduced at trial.
Okay.
Number two is, case is scheduled for trial today and there won't be any continuances. Number three, the prosecutor wants jail time.
Sure. So on this record, the judge was appropriate to deny it and conclude, I would suggest implicitly, that there's no substantial issue raised with respect to ineffective assistance because regarding the first part, there's a possibility it may not be introduced. That is true of every piece of evidence. It is not incorrect advice, and therefore it cannot be ineffective assistance of counsel.
If you deconstruct the three, I would agree with you. But if you take the three as a whole, because they literally come up in 6 sentences in his affidavit, these are the three things that happened to me as the defendant.
So my position is that 0 + 0 + 0 = 0.
Okay, so why are 2 and 3 0?
I'm happy to address those. So with respect to the no further continuances, the purported lie that, which is what the defendant is essentially saying here from his trial attorney or plea counsel, is that there would be no further continuances. That is belied not only by the tender of plea form and the sidebar conference and appellate counsel's own acknowledgement that the judge was likely to give a continuance, but the defendant's father's affidavit that was submitted in support of his motion for new trial. The defendant's father says something to the effect of what the parameters of what was going on that day. And so, I'm sorry, I'm confusing the issues. That's with respect to the jail time. The defendant's father recites in his affidavit that essentially that we could work out a deal with no jail time. And so that's belied by the record, and that's the tender of plea form that also contradicts the defendant's affidavit.
But what about, on the jail time point, what about Justice Ditkoff's point, which is the jail time, yeah, they know they may be able to cut a deal for no jail time today. That's what they ultimately got. But what he's saying is, I want to go to trial, and my lawyer is telling me if I do that, I may go to jail. The father didn't say, we know that's not going to happen, did he?
No, but so And I apologize, my understanding of the defendant's claim is that because his attorney purportedly told him the Commonwealth wants jail time, that induced him to plea.
Exactly.
And what I believe it's the defendant's father's affidavit that says the defendant's attorney came back and said, no jail time here, we're good to go.
No jail time if we go to trial, or no jail time if we plea today?
I apologize, I'm looking at the defendant's record.
Big difference, though, isn't it?
I'm not sure that it is, Your Honor, because there is no, frankly, there's no evidence on this record to support the defendant's contention that his attorney lied to him.
Except that he says he did.
Correct, but
For
what...
which you could have an evidentiary hearing and let the judge make a finding.
Except that the judge, in the wake of the collateral consequences and the late emerging claims of the defendant, that's the first part that would have let the judge discredit the defendant's affidavit. Secondly, that some of the defendant's affidavit is contradicted by the plea hearing, the non-evidentiary motion for new trial, and the record evidence.
So you started by saying the plea hearing contradicts it because the judge, I think what you're saying is because the judge suggested that he would be willing to give a continuance.
That's correct.
But do we have any evidence that the defendant knew that? I thought there was some comment about white noise being used at the, it was a sidebar comment, right? A sidebar conversation.
Your Honor, I apologize to the court. The record is so voluminous that I'm struggling to point to the specific language in the record, but on the continuance point itself, I'd point to the defendant's assertion at the plea hearing where he says, I've been wanting to get this over with. It's been interfering with my work. I need to close this case. That's on the plea hearing as well, that the defendant was incentivized to plea on that date. And so there's a number of contradictions.
That's not a contradiction. It's just something that weighs on the other side.
Well, it
and I don't disagree with you that it weighs on the other side.
Contradicts the defendant's assertion that he, in his affidavit, that he wanted a continuance.
Oh, hold on. Doesn't say that. He doesn't say that exactly. Okay, I understand your point.
His affidavit did not?
Yeah, it doesn't say I wanted a continuance.
But the position...
It says, what it says to me, although it doesn't say it artfully, is if we're not going to get the video in, I'd want a continuance.
Certainly, but at the time of the plea hearing, he did not want to continue the case given its impact on his career. And his inability.
And maybe I'm missing it, being that this has already been going on for 18 months, would you consider the 6 months so I could get to work? There's been no issues to that, and the judge says the obvious thing, which is you can work while you're on a quaff.
Yes, but I think it's the pending case that was interfering with his ability to work is what I believe is referenced, as opposed to the case being terminated. I think here... That
makes sense.
I think ordinarily a judge is not required to accept a defendant's self-serving statements. I think here the defendant's own affidavit indicates plea counsel had all of the evidence, and what strategic decisions counsel may have made with that evidence was not manifestly unreasonable, and the defendant's showing failed.
Say we knew the video was coming in. For whatever reason, we knew it.
Motion in limine before trial, or just...
We had a crystal ball that said this video is coming in. Wouldn't it have been irrational
for the defendant to take any plea?
No. And the reason I say that is because what the defendant admitted to sufficient facts to was that the assault and battery in the parking lot occurred inside the vehicle, and the vehicle... inside the vehicle cannot be seen on that video.
He actually didn't admit to sufficient facts about that. He said, no, Judge, that's not true. Quote, unquote. There is a different argument, which is he admitted to the other assault. He's got two assaults.
And none of the evidence that he complains of here contradicts anything with respect to that docket. Unless there are further questions from the court, I'm happy to rest on my brief.
Thank you very much. The case is submitted. We're going to take a brief mid-morning break and then continue with the Sorb case.
Hold on, right, please. Court is now in recess. Court, all rise, please. Court is now in session. Please be seated.
Still good morning. Welcome back. We are now here for the fourth case of the day, 2021 P808, John Doe number 342170 versus Sex Offender Registry Board. And I would remind the parties that this is impounded, so please, no names of either the petitioner or the victims.
Good morning, Your Honors. Brandon Campbell for John Doe. The first issue I argue in my briefs is that I don't think that there's any debate here that there was an error in the application of Factor 2, repetitive and compulsive sex offending, which is a high-risk factor. And the Superior Court judge found that there was an error. My brother concedes in his brief that there was an error. And interestingly, this court had a case about, I want to say about a month ago, Doe 22188, which clarified what
second Doe.
Yes, Judge Milkey was only on the first one. I was on both.
The Doe numbers case, whether error may have, and the test being whether the error may have affected the classification. So I think what the inquiry here is on this issue, for all intents and purposes, is could this have been a level 2 classification? And as difficult as it is to read the police reports and the victim impact statements, I do not think it is reasonable to say that this could not have been a level 2 because there were a lot of mitigating factors.
The error you're talking about with respect to Factor 2 is not that it doesn't apply, but just that they applied too much weight?
Yes, and I think it's arguably, I think Factor 2 is the most important factor in all of the factors, because if you think about what the purpose of the sex offender registry is to prevent, warn the public about dangerous sex offenders who may reoffend, what is more prejudicial than a finding that goes to someone having a psychological compulsion or obsession that causes them to reoffend?
But we got that either way. He just has too much compulsion.
I think it's
we're allowed to have weight, just not full weight.
Correct, and I agree because even though Judge Wilkins took a pen to sentences 2 and 3 of Factor 2, the part that says whether there is a criminal charge or conviction, only then can there be the highest weight given. So we have a hearing examiner here who says that she's giving full weight. It's clearly wrong.
Can I just press you on
something you may be conceding? In terms of what he was confronted with
regarding the earlier sex offense,
the hearing officer focused on the MBTA investigation. I'm having a hard time seeing that where
what linked his knowledge to the MBTA
investigation was his statement that they were investigating me for having sex on an MBTA bus. How do we know he's even talking about the same incident
with regard to the
particular ex-girlfriend in the bathroom? And is the reason you're not arguing that because separate from the MBTA investigation, which may have been about some internal MBTA policy as opposed to an illegal rape off the bus, we have the 209A proceeding, and that separately could be the confrontation that matters for Factor 2 purposes?
Practically speaking, number one, I am not conceding the reliable hearsay issue at all. I'm not conceding that the board established that 1997 incident as fact. In terms of, which issue I went with first, frankly, I have one where there's an error, and then there's another one where I have to argue about the error. But I'm not conceding that, and I do not think that that was established with reliable evidence.
Putting
The reliability of the hearsay aside,
Yes.
on this record, could the hearing examiner have simply looked to the 209A evidence of the earlier sex offense as the confrontation for purposes of Factor 2?
I'll say this, it definitely weighs against my client, but there's so many more things I think that make this hearsay unreliable, such that it should not have been allowed to be relied on just on this record. And so there's a whole litany. I don't, contrary to what the hearing examiner says, I don't agree that it's a particularly detailed account. It is, a couple paragraphs in very large handwriting in a 209A affidavit. There's no evidence of any witnesses or medical corroboration.
but she's pretty specific
About the charges, you say at one point she wasn't specific. Speaking only for myself, I don't read it that way.
Well, still, one of the most troubling things that I think, and I know, so there is no charge and no conviction, okay? I get that that isn't a requirement, but that certainly weighs against any kind of corroboration. But we have if you look at this restraining order affidavit, and I realize it issued ex parte.
But there was a follow-up hearing.
There was a follow-up hearing, and it appears that a police officer testified, and I find it, I think it's very important, the fact that the judge deleted the findings that Doe was dangerous. And
Do you have the transcript of the hearing?
we do not, and we do not have an obligation as the petitioner to prove
He
this.
deleted the firearm provision and the imminent threat.
Yes,
So he obviously had concluded that the defendant wasn't about to rape her again. But since they presumably broke up after that, that seems sensible. I don't know how you get from that the judge didn't believe that the sexual assault happened.
I frankly don't get to how you delete those findings and conclude that she's credible, honestly.
Well, but how do you, if she's not credible, then how could you possibly extend the 209A order?
Well, sometimes these things get, there's a large amount of interpersonal conflict. We know from statements in the record from the petitioner that he believed that these were motivated because he was leaving her for his future wife. I also find it extraordinary that the MBTA would, if you find these, allegations credible, would restore him to a position as a bus driver if he is in fact, has.
Under circumstances where there's no charge whatsoever, all he has is a 209A that I think had expired. I don't find it extraordinary, but of course I have some specific experience. Let me ask you this, which is what occurred to me. So this argument is to some extent the following. All that really should have been credited here is the evidence with respect to what he was convicted of and nothing else. And here's what bothers me. So there's a hearsay document put in that indicates that he raped someone 10 years before the index offense. Can't we use the index offense to help us believe that the 1997 event occurred?
I think they're a lot different. I don't think that there's any kind of modus operandi that, yes, there is sexual assault.
A violent sexual assault?
I think it's a lot different. One is in the context of a dating relationship with someone.
Yeah, there are differences, but it's a violent sexual assault against the will, including actual penetration. I mean, it's a subsequent bad act, you know. I don't know how it would be treated in a criminal case. Actually, I probably do. But for purposes of SORB?
The ages of the people involved were different. And also with respect, going back to the first argument about talking about, you know, whether they prove compulsiveness, you know, there's a 10-year stretch between this. So I don't see any acknowledgement by the hearing examiner in the findings that this bears on it. And by the way, all of these factors it is a qualitative analysis. So it's not just you say, oh, you know, this factor applies, this factor applies, and then here's your number. It is how much weight is to be given to those factors. And factor 2 is arguably, as I said before, one of the most important factors.
Can I press you on something?
With regard to the
index sexual
offenses, you commented that it's
hard to read the police reports. You certainly will get no argument about that from me. And, you know, it's hard for me to be shocked by some of these. The facts of this case are fairly shocking. That said, if she had been a few months older, how many of these offenses
would have gone away as criminal offenses?
Given that
there are a lot of people who do some very strange things.
Certainly, a lot of the offenses with all of the offenses with the age element. You know, the other young woman involved in this was 16. There wasn't anything that was brought there. I know that the hearing examiners also applied factor 3. I cited several cases where this court reversed and remanded where there was an error with respect to factor 2, even though factor 3 applied simultaneously. And that, again, just goes to how serious a factor and how weighty, heft is one of the words used in one of the cases, that factor 2 has. By the way, this can this type of finding can follow him for literally decades, because every reclassification that he goes to, this will be brought up again and again and again. And I was part of a case just recently with this court affirmed a level 1 classification with an offense that was over 30 years old. So these have long-ranging impacts, and they are prejudicial, very prejudicial on an ongoing basis. Going back a little bit, I think you asked about factor 3, or maybe it was you, Justice Milkey. There is a contour to factor 3 with the adult and child. This was on the outer edge of it. It is weightiest with children that are under 13, because in that case there is an inference of deviant sexual arousal. That is not present in this case. We have a person.
I think there's some deviant sexual arousal in this case.
Not from there's no evidence from there's a pathological issue is what I'm saying. Very troubling, yes, but is it you know, any kind of disorder? There's no proof of that.
I didn't see anywhere where you raised your issue about factor 34 before the Superior Court. Am I missing it?
I would look again, Your Honor. My recollection is, as part of the overall substantial evidence, there was quite a bit of argument about his lengthy period of sobriety, his extended probation, his, actually being a leader and helping other people become sober and become a leader in the sober house. I think that there's quite a bit there. Maybe it wasn't stated as artfully as it could have been, but
Where did you mention factor 34 at all in the Superior Court?
I don't have that in front of me, but even if it was not, even if he didn't say the number, I would submit that he made the argument in substance.
What do you mean he? You?
No, it was
you're not.
me.
I'm sorry. You're not the. I'm sorry.
Prior counsel did.
I'm sorry. You're absolutely right. Okay.
I was confused, I'm sorry, this is one question. I was confused a little bit about what the state of the mitigation evidence was, because in the hearing officer's decision, he talks about a 2011 letter, but I got the sense that a whole lot of people showed up to testify at the hearing. Are they just not addressed in the hearing officer's decision?
The transcript is in the record. It's at the end of the exhibits. There were 4 or 5 witnesses. It was a very challenging hearing. It was at the start of COVID. My client was incarcerated. They were trying to do everything by video conference, and there were constant interruptions.
But there were live witnesses who testified about supporting your client.
Yes. Yes.
And those live witnesses are not really referenced. Instead, we get this discussion about a 2011 letter from his defense attorney. Am I missing something here?
Are you talking about my brief, or are you?
No, I'm talking about the findings of the hearing examiner.
Yes.
Hearing examiner doesn't really talk about that, except I think one thing that bothered him was that those people didn't believe that he had actually done it, right?
Yes, I do recall that.
Okay, I'll take a look.
Okay. Any other questions?
No.
I see my time is up, so
Thank
I
you
will
very
step
much.
aside.
We will hear from Mr. Chennai.
Thank you.
If it pleases the court, David Chennai for the board. I don't think I'm ever going to shake factor 2, and it seems like it's constantly coming up on me. But
And somehow one of us gets on every
this is
one of
true.
those cases.
This is true. DOE 22188, I'm hoping is finally done for good. You never know, it may come through again at some point from a reclassification situation.
So let's go to both DOE 22188. Why doesn't some combination of those 2 cases say this has to go back? Because it's not our job to decide if the hearing officer would have come out the same way had he properly applied factor 2.
I think you have to look at the most recent DOE 22188, as Justice Ditkoff wrote. The first part of the analysis is, and it's applicable here, is that the evidence in this case clearly state what the classification level should be, regardless of whether he gave minimal weight or maximum weight to factor 2. It's just, truthfully, it's right now and I've been doing this since 2005, it's in my top 5 weirdest and oddest and really depraved type of sex offending behavior. It's one of those ones that I hope when I'm retired I'm no longer thinking about. So I think that the first part of the 22188 analysis is met here. The facts in this case clearly dictate the classification level, and the level is a level 3 based on this individual's behavior. One of the differences...
Before we go there, though, what about my question
To the petitioner's counsel that at least some of these charges would not have been illegal if the victim was old enough to consent, which she was just a few months away.
I don't agree totally. I think that in the the final encounter, I think those were forcible rapes. Whether she was an adult, I don't think she
Convicted of forcible
consented
rape
to
of
it.
a child, right?
he was charged with forcible rape of a child,
And convicted of it, so.
convicted of it. But what I'm saying is that if
There'd
she
still be
were...
forcible rape. It's not like you can forcibly rape a,
Correct,
adult.
but it would have been rape. I don't think that the facts indicate that the young lady was consenting to the behavior that she was subjected to.
No, okay, but
What makes this case,
in your top five, as it were, is some of the outside color of the facts and the particular nature of some of the sex acts here. And all I'm saying is there's something of a distinction between many of the sex offenses he was convicted of and that. I'm not being particularly articulate, but I think you understand what
No,
I'm
and
saying.
I understand what you're saying, and I agree with that in part. But again, I think if this young lady was 16, it was...
As the other person was.
Right, and the other person seemed to be consensually involved. The other person was actually assisting in some of the behavior, especially in that final encounter. So we got to separate her somewhat. She was not being forced to do this. It appeared that she was consenting individual and was involved directly in some of the abuse of the 15-year-old. The burning of her with the cigarettes, the spitting in her face, the hitting her, as all part of the sexual behavior of both she and the plaintiff. So I think when you look at it that way, she's a different entity in this case. I think what you have to look at is the facts.
Help me with this. If there's no 1997 event, okay, just take it out of the picture. Assume that your brother's right about that. And he's now 54 years old, right? And this is an event that had occurred 15 years before?
Correct.
16 years before? You make it sound like he's a level 3. And if you take the 1997 out of play, based on sort of the panoply of cases I've seen, that's not as obvious to me. What makes that obvious to you?
What makes it obvious to me is that, again, the bizarre nature of the sex offending behavior, the violence, just the debasement of this young lady by this individual on 3 occasions, but especially that last occasion, the debasement that he perpetrated on her. I mean, it was more than just having sex with her. It was debasing her. Secondarily, he's been in prison for the last 9 years. He was in prison at the time of this hearing. And
So of those 15, he'd been out 3, is that right?
Correct, and that was while his charges were pending. And in the interim, the 9 years he's been in prison, unlike Doe 22188, who had numerous mitigating factors, this individual completed 2 classes, the CRA, and he completed the Able Minds program. Now, the hearing examiner didn't consider the fact that he didn't didn't participate in sex offender treatment because he claimed he had an appeal pending, but at the same time, he can't say that he benefited from any type of treatment. The only thing we know he's done is that he's worked on his sobriety and done very well prior to his incarceration, but he's been incarcerated for the last 9 years.
What was the mitigation evidence? Because I read that hearing, it was almost like I was reading 2 different stories about mitigation. I read the hearing examiner's decision, and he starts talking about a lawyer's letter from 2011, which immediately to me is like a red flag. You mean you couldn't get somebody in 2019 to say something nice about you? But several people testified at the hearing. So why are we ignoring that? Why are we ignoring the fact that he has a girlfriend, that they're saying that he's going to have a place to, when he comes out of prison, to be with people who are supportive?
Well, first of all, the hearing examiner discussed all the testimony in the section factor 33. Discussed basically he looked at this, the hearing examiner looked at this as supportive networking, which factor 33 covers. Stability in the community is a little bit different. That is showing that he's going to be employed, what his circumstances, residential circumstances. Now, the girlfriend didn't testify that she was going to give him a place to live. On cross-examination, she said, well, he could possibly live with me. She never committed to that, nor did he write an affidavit that says, I'm going to be living with my girlfriend. The stability is different than the support network. The hearing examiner took into account all of the witnesses as it applied to his support network upon his release. But he had very little evidence as to what he was going to do upon his release, where he was going to actually live, whether he had a job lined up, whether he had done programs while incarcerated that would help him with his transition into the community. There was none of that brought forward. So when it comes to his future stability, it's hard for the hearing examiner to say, I see that he's going to have a stable living environment upon his release. And that's, the hearing examiner gave the stability minimal weight, but gave the support network moderate weight because he did, and the hearing examiner did say he does have what appears to be a strong support system upon release.
What? Oh. I'm kind of about to go on a lark, so if you've got something more.
I'm going to go back to factor 2.
Yeah, you should do that first.
Okay. Hearing examiner focused on the MBTA investigation as the confrontation. The link is his statement that he was being investigated by the MBTA for allegedly having sex on a bus with his ex-girlfriend. Help me, putting aside the 209A, help me how that shows that he was confronted with a sex offense.
Well, setting aside the 209A, again, it's the hearing examiner made that inference. I think the plaintiff made it clear that that he was breaking up with this girl to date the woman that he married. I think that is close in time with the actual 209A. I think it could be alleged that she was the girlfriend. And I think the hearing examiner made that reasonable inference, that this was the girlfriend.
But the facts of the earlier sex offense are established in the 209A, correct?
Right.
So is it your position that none of this matters because the 209A stuff came in and that shows the confrontation?
I think I got really two positions on that. As for whether or not his statement refers to this woman, it still shows he was investigated by the MBTA for a sex offense.
Sex on an MBTA bus, which for all I know is against MBTA policy.
I'm pretty sure it's against MBTA policy.
But more importantly, the 209A puts it in a courtroom in front of a judge, these allegations. Now, what's interesting is under DOE 3177, the hearing examiner only has to find that the evidence is reliable and that the events occurred by a preponderance of the evidence. That's the same standard that the judge used in...
I understand that, but the question is what shows that he was confronted with this? And I'm trying to probe whether or not the existence of the MBTA investigation shows it, or should the hearing examiner have really been looking at the 209A proceeding itself, where he, according to the record, did appear at the second hearing and presumably was confronted with her allegations of rape.
Well, if you look at it and say, okay, the hearing examiner made an error in the evidence on the MBTA, then we've got an issue whether or not factor 2 was misapplied. Now, you've got the 209A, which, again, the woman is in court alleging that he was sexually assaulted her. A judge has found by a preponderance of the evidence that occurred.
Wanting a consequence to come from that's got to be confrontation, isn't it? You know, if you're in court as a defendant in a civil case being told that something may happen to you if a judge concludes that you engaged in a sexual assault against this particular plaintiff, isn't that enough?
I guess I'm confused by the question.
He's trying to help you out.
Yeah, that's why I was confused by the question.
You're confused I trying to help you out, Mr. Shania? I don't get it.
No, I agree. I believe that, that being in a courtroom, having this allegation made in a courtroom is a confrontation, and it's...
I want to make sure my colleague has a chance.
My lark. What happens if after the after the classification, the index offense gets overturned on appeal?
If the index offense ever gets overturned on appeal, then the board would bring the case forward and dismiss he would no longer have to register, because that is the case.
What if part of it, what if there was still a sortable offense that gets affirmed, but another conviction that happened at the same time gets overturned?
If it's a partial, if there's still a convicted sex offense, then he would still be subject to this case and the classification, with a right in 3 years to seek reclassification.
You couldn't ask for an earlier redetermination based on the...
I think the only thing you can ask for an earlier is if you have a medical condition that would currently impair your ability to commit a sex offense. I think that's the only fast track for a reclassification. One of the things that's changed over the years is that the reclassification used to be 5 years. The SJC has made it 3 years, and we've been adhering to that for all individuals. Even those, in fact, we don't even use the rule anymore where an individual has to be released from incarceration for 5 years. It's 3 years from the last classification, and if an individual is within that 3 years when he's released, that individual has a right to a reclassification at that time.
And so just to square the circle, that's a terrible phrase, the fact that we reverse the child enticement conviction for this offender doesn't matter until the redetermination happens.
Correct.
All right, I just would like to do my ritual complaint that the trial transcripts, which were available, were not gotten and presented to the SORB examiner, as I do every time.
Noted, Your Honor. And I do let the board know your concerns, but I'm not that high up in the chain of command.
Any chance the Factor 2 regulations are coming out anytime soon?
We're in the process of rewriting all the regulations, and Factor 2 is going to be rewritten in accordance with DOE 22188 from the Justice Wilkins decision forward. It is being implemented properly. Here it appears that it was an issue of the weighting as opposed to whether or not it applied in the hearing examiner's mind. But it's not a circumstance where, because he sexually offended against a girl 3 times, that they applied it. They found a confrontation for the reason for the application of Factor 2 in this case.
Thank you very much. The case is submitted.
Thank you.
Our next case of the afternoon is 2022 P466, KRISTIANA LACCETTI, I hope I pronounced that correctly, versus Stephen G. ALEXANDREDACOSTA, also known as Steve Ellis.
Members of the panel, may it please the court, Attorney Jeff Simons for the plaintiff. What lies at the foundation of this is the fact that expert testimony is necessary in order to assist jurors on issues that are outside of their common knowledge. In this case, there was a motion in limine filed to preclude photographs of vehicle damage. During pretrial arguments, the defense vigorously argued that they should be able to use those photographs to show that this was a minor accident, and as a result, the plaintiff could not have sustained the injuries that she claimed she sustained in this accident. In doing so, the defense is arguing that there is a correlation between vehicle property damage and injuries. However, as Judge Deacon pointed out, and as the scientific literature points out in our brief, there is no such actual correlation.
Can I stop you on that?
Yes.
There's some nuances here that you tend to gloss over a little bit in the brief. You say there is no
Actual correlation. Well, correlations mean many different things. Partly you're saying there's no direct correlation, or there isn't a linear correlation. And then with regard to some of these issues, you say actually it can even be a negative correlation. It can go in the opposite direction. But
those are not all the same thing.
and there can the overriding point you were trying to make, as I understand it, is just because you have a low-impact crash that doesn't do a lot of harm doesn't mean
That your client didn't suffer this.
soft tissue kind of injury. And you, unless I'm misreading this, you prevailed in making that point to the judge. And beyond that, isn't this all really a matter of either cross-examination
Or putting on your own expert to make that point crystal clear to the jury?
So the problem is that the prejudicial nature of photographs of vehicles with very limited property damage, that in and of itself will allow a jury to think, oh, this accident could not have caused these serious injuries that the plaintiff is suffering.
But the reason they think that is because they're bringing their common sense to the courtroom, which is what we expect. Is your argument a 401 or a 403? You just talked about the prejudicial effect. Do you agree that the evidence of photographs of what the cars looked like after the accident is relevant?
It's relevant if the photographs are being used for some reason other than to prove that this was a minor accident.
How do we know they weren't used for that?
From what actually happened at trial and
But
from
you
the
haven't
pretrial
given
arguments.
us what happened at trial. You've only given us a portion of the transcript. How do we know it wasn't used in the parts you haven't transcribed for those purposes?
Well, we did transcribe the opening, the closing, all of the pretrial arguments, and the witness examinations.
Not all the witness examinations.
No,
We're missing tons of the witness examinations.
I don't have to say, here's why I'm using the photographs in order for the photographs to be relevant. Both witnesses testified about the fact they were involved in an accident. I'm a juror. You got photographs of what happened to the cars in the accident? I'd like to see those. They're relevant to me trying to evaluate what happened, especially when one of the issues is, how badly was the plaintiff injured?
Well, I think the problem is, and to speak to something you had raised earlier about it's within their common knowledge when they come to court about what damage can cause what injuries, is that it's a mistaken belief. It's
Where is your proof that that's a mistaken belief? Okay,
So-
well, let me just finish. Because if you're telling me that if I go down the road on I-95 and I see a car overturned on its head, as opposed to I go down the road on I-95 and I see that two cars have hit each other and I can barely see any damage, that I can't know as within my knowledge that there's a much higher likelihood that the car that flipped over, somebody's badly injured? Are you telling me that?
No, I'm not taking that
Okay,
position.
so what are you telling me is not my common knowledge then?
It's that in an accident where there is either no visible damage or just minimal visible damage, that somebody can be seriously injured in an accident like that. And some of the scientific literature that we cited shows
But that's a very different thing. I mean, nobody excluded that from being argued by the plaintiff. The defendant didn't argue that. They didn't say, because this damage is X, no one could get injured. They didn't say that. In fact, they were precluded from saying that.
They were precluded from making the direct argument, but what our appeal is that the photographs should not have gotten in at all, because it then allowed this indirect argument and this inference to be made. So in the opening arguments, they started off by calling it a minor accident. So that planted the seed that this is a minor accident. That's important that you keep in mind.
And you didn't object to that?
I'm sorry?
And you didn't object to that opening on that ground?
We did not object to, because that was permitted. There were lengthy pretrial arguments about what would be allowed and what wouldn't be
Deacon
allowed.
said they may not argue that serious injury is unlikely to result in less serious collisions.
Yes. They may not argue.
What else did you want?
So in addition to that.
I know you wanted the pictures not to come in, but.
Yeah, the pictures, if the pictures didn't come in, then I don't think any of these arguments would have been able to be made, because after that in opening, the defendant is called first. We called the defendant first. And what happened during the defendant's testimony is that these photographs are introduced, and not just the 8.5 by 11s, but they're blown up. The blown up photographs are introduced and shown to the defendant, shown to the jury, and It's basically put it out, now there's a little bit of denting here, there's some damage there. So it's kind of incrementally being presented to the jury.
And when did you object to that?
We did not object to that. And I think that the question of whether or not we preserve the issues on appeal, we did preserve the issues on appeal because
Well, you preserved the admission of the photos. Judge Deacon says you preserved it. But I don't see how you've preserved anything else you've raised.
Well, separately from that, when the expert witness testified to there being a relation between property damage and injuries, we did object to that on record.
You objected, the judge took it benigni and said, if you feel that he's failed to lay a foundation, you should renew your motion, and I'll address at that point what, if anything, to say to the jury. And at least from what you've transcribed, you never made that motion to strike, you never asked for anything, although, for all we know, the judge in his final charge told him to disregard every word of Dr. Dalton's testimony, because you haven't given us that either.
I understand. I think my point is that these indirect arguments and these inferences that were made throughout the case, in the opening, in the defense direct, when the medical expert came up, he made that testimony was elicited where he made the connection. So now the jury's understanding, if they hadn't understood yet, that, oh, this is something we should pay attention to, that these photographs mean that the plaintiff could not have been injured.
Well, which one, when the expert, so we're jumping back and forth a little bit, but as I understand it, you're complaining about two pieces of evidence in particular. I mean, at the end of the day, this is just an argument about evidence that came in that you think shouldn't have. One is the photographs, and the other are statements by the doctor. Have I got that part right?
That's correct.
Okay. So one of the things I saw, and I looked for because it bothered me, frankly, is the testimony of the doctor where, in response to the question, how do you know it was a mild neck strain, he says, because I looked at the photographs. Of course, you then ellipsed the rest of his answer, but most importantly, there was no objection to that question. Am I right?
Yes, the objection was
to an earlier point where, as it's been described by my colleagues, where the judge actually said, I sustain the objection, but I'm going to take it to bene.
Correct.
Which is a pretty unusual thing to do in a jury trial. It's a jury trial, right?
It was, yes.
Yeah, that's...
Let's say the photograph had showed a mangled car. You're saying that a plaintiff couldn't get that photograph in without a biomechanics expert?
So if we were trying to use the photographs simply to argue that this is evidence of the fact that the plaintiff sustained these injuries in this accident.
But why do you have to be so confined? It's the jury wants to know more about the accident, and a picture of a mangled car gives a pretty good picture.
Well, I think the question is what is the actual relevance of these photographs? Because, I mean, a race car could be involved in a very serious collision where you see mangled metal
Could be, but, well, I'll tell you what I think the relevance is, and then you can tell me why I'm ignorant. Yeah, it's true. You could see very minor damage, and someone could be injured in a way that requires them to have medical care and incur costs. But it's less likely than if somebody has what Judge Milkey's just described. Am I wrong about that?
I don't know if it's less likely. I think that's the question for an expert. I mean, the jury doesn't understand the factors that play into an injury occurring. A race car driver can walk away from that.
Some jurors do.
I mean, some may, but I don't think the typical juror has an understanding of the delta V's and the force that is absorbed by the metal.
Right, but see, in fact, the injury is related to the deceleration or acceleration that occurs on the body. In fact. Okay? And intuitively to most jurors, they get that because they've lived long enough to be injured.
But I don't think that the typical juror understands that metal can absorb force that is then not transferred to the individual. So in a traffic accident case, when you don't see any damage to the metal, that's because the metal then absorbed the force. And some of the papers that we cited, they said that... Because
they've never been on a trampoline?
Well,
I don't mean to be facetious about it. I think when I read this, I thought it was very interesting and because I'd never ever focused on it and I read the case law. But what I really think is, great, have at it. Put your expert on the stand and let your expert explain all this to the jury. But the notion that we're going to take the photographs away from the jury because they can't understand that certain things absorb energy better than others, or that when they get slammed in the head by a really hard thing, it hurts a lot more than when they get slammed in the head by a really soft thing?
Well, so I guess then I don't think that it should be the case that in any traffic accident case where there's minimal damage that the plaintiff should have to bring an expert in to explain the forces to the jury. I mean, it's a defense that's being presented by the defendant.
You seem to want us to hold, and correct me if I'm wrong, you seem to want us to hold that the severity of the physical damage to the cars has no relationship to the likelihood of serious physical injury.
As a matter of law.
I'm sorry?
As a matter of law.
I think it's more narrow than that. I think it's that photographs cannot be used without expert testimony to correlate the damage to the vehicle to the injuries of the person.
So you want us to say without expert testimony, you can't say there could be a relationship between the amount of physical damage and the likelihood of physical damage?
Well, it's all about the photographs, though, because that's what really, I think a jury will see the photographs, and where I don't think they don't have a correct understanding, even though their intuition may point them in a different direction. Their intuition may say, yes, if the car's badly damaged, then there's probably more injuries inside. But I think in court,
how are we supposed to know that intuition is wrong?
Well, I think that's why we cite the scientific literature. That's what
you put in some studies that you never gave to Judge Deakin, but one of them says there's 20 other studies that go the other way that they think are methodical, method problems. That's not the right word.
Methodological.
Thank you. I mean, so how are we supposed to, based on the cherry-picked studies you've given us that weren't given to the judge, to decide this scientific issue?
Yeah, I don't think that we're here to say the scientific issue needs to be decided, but I think the fact that there's science on both sides arguing that there's either a correlation or there's not, there's been these studies, shows that this is not something that's within the common knowledge of the jury. I mean, the missed theory of evaluating insurance claims, this mild impact soft tissue, that's in some of these studies have been proven to be false. In that theory, essentially insurance companies will just deny claims if there's under $1,000 in property damage. And what these studies are saying is that's not an appropriate way to take a look at cases when you're trying to evaluate whether or not
that insurance company policy is not on trial here.
No, but I think it's very consistent with the arguments that were being made at trial, which is essentially that, look at these photographs, this is a minor accident, which proves that these injuries could not have been caused by this accident.
How are we supposed to determine whether any error is prejudicial, considering how much we're missing? We don't have your closing argument. We don't have the final charge. We're missing much of the witness testimony. We don't have your client's direct testimony. We don't have much of Dr. Dalton's testimony. How can we evaluate the prejudice under the circumstances?
I understand, yes. In the closing argument, the defense highlighted what they called the main theme of their case. The main theme of their case was that this was a minor accident. And they developed throughout the case, why is that important to the jury? Why is that it's a minor accident important to the jury? Because the photographs prove that these injuries could not have been caused. So the jury is seeing this throughout the entire case. And they're now, when they're deliberating, and they did actually end up finding against the defendant, found that he was negligent, found that his negligence caused the plaintiff's injuries, but only awarded $10,000 in damages when there were $60,000 in medical bills.
Can I focus on that for a moment?
Sure.
Because I'm looking at the special jury verdict form. And you're correct. They found the defendant negligent. They found that your client was not negligent. And they specifically found that the negligence of the defendant caused the plaintiff's injuries.
Correct.
And for me, at least, your strongest argument is there's an injustice here because in spite of that finding, they didn't give her even her medicals.
That's correct.
Why isn't the path
You should have taken at that point
was to argue to the judge that either there was an inconsistent verdict or the weight of the evidence was so strongly in your favor on damages that an additor and a 59A motion for a new trial should have been granted, because that targets the particular problem you're focused on.
Right. Yes, I understand that that was not something that we were able to pursue. It's not something that our client was interested in, and so that wasn't something that we pursued, and the appeal was on the motion in limine. It wasn't on that specific damage. But I do think that what you pointed out, that is, I think, evidence of that prejudicial impact on the case.
You construe that finding as they found responsible for, caused all the injuries claimed?
Well, I mean, the special verdict form doesn't specify whether or not it was all of them. I think an argument could be made
Wasn't
that.
one of the issues here that the injuries for which she was claiming medical bills were years out from the accident?
Yes, that's
So
correct.
there was a real question about, whether everything that she was claiming damage for was causally related to this event, which had occurred 6 years before?
That's
Some of the
correct.
medicals?
Yeah, I mean, we don't know,
It wasn't
but
quite black and white then, was it?
no, it wasn't. But I mean, that's kind of the point. I mean, I don't think it's speculative to say that this impacted it, though, because it was identified to the jury as a main theme, the fact that it was a minor accident, and it was cited throughout and emphasized throughout the entire case. Thank you, Your Honors.
Thank you, counsel. We'll hear from the defendant.
Good afternoon. May it please the court, Doug Price for Stephen Ellis. This case is about abuse of discretion. I think that should be the starting point. Judge Deacon let in photos of cars in a motor vehicle case. That's what happened here. This is something that judges have done thousands and thousands of times for 100 years, and he was well within his right to do that. They say that there's several cases, several jurisdictions. There's really only one jurisdiction. The Hasty case that he cites, the Ohio case, if you look at the cases that follow that, the Maybaum case 8 months later basically wipes that out. The only case really...
Hasty just says it's within the judge's discretion.
It does. It does.
Which many of the out-of-state cases say.
Hasty basically says it's limited to the facts of just that case. It's, as you said, within the judge's discretion. And then there's a strong dissent in that. Then Maybaum, which is 8 months later, basically looks at the dissent, cites the dissent in Hasty, says the admissibility of photos is in the discretion of the trial judge, and generally they're relevant to prove the extent of injury. Your Honor, I think this is something a matter of just, as you pointed out, just a matter of common sense. It doesn't need to be an exact certainty. I agree with all the points that were raised, that you can have a minor accident, somebody can be injured, or you could have the rollover accident that was discussed earlier where somebody walks out unscathed. Nobody's saying that. It's whether or not it's relevant. It's in terms of probabilities, what's likely. Judge Deacon recognized that. As you saw, there was a record appendix between pages 121 and 136. There was the whole back and forth about this whole issue. Judge Deacon carefully considered this issue. It wasn't like he ruled right from the bench. He actually took the day, read all the cases, had a thoughtful discussion about it on the record, and did limit me somewhat. And respectfully, Your Honor, I think I stayed within the bounds of Judge Deacon's order.
What do we do about the problem that sometimes common sense is just wrong? The analogy plaintiff's counsel used was the earth is flat versus the earth is round. In fact, in this area, it's well understood that what makes modern cars far safer than earlier cars is their ability to collapse. So there often is not a direct correlation between what the car looks like afterwards and the injuries at stake.
Your Honor, that's the Mason case that I cite to kind of actually deals with that. That's 388 Maryland 37. It doesn't have to be certainty. It's just in terms of probabilities. That's what makes it relevant. And it's common sense. This is just a starting point. There's other as that case talks about in also the LACCETTI case, there's other pieces of the puzzle. It's just one piece of the puzzle, just one thing to argue. Common sense is just a starting point, not only with the jurors, Your Honor, but the judges do this all the time when evaluating and letting in evidence, determining what's relevant. Common sense is playing a role constantly throughout the trials.
You say that you thought you hewed to the line that the judge drew.
Yes, sir.
But you went right up to it, didn't you? You asked, does the severity of the accident make a difference? You asked that multiple times. So you used the word severity rather than property damage, right? And then your witness on page 253 of the record appendix says, and lesser degrees as low-velocity accidents are minimal damage to cars. Most people don't get symptoms, but some people do.
You're talking about...
So your doctor just somehow just migrated right into the damage to cars? It wasn't anything that came up maybe in prep?
Your Honor, first of all, that wasn't exactly... he testified based on his experiences. That was it. And as was pointed out earlier, there was no proper objection preserved on that. But I think a doctor can testify about...
Well, no, there was an objection
to
that one. That was objected to. That's the one the judge took de bene. But then, you know, sort of near the end, what about her neck? Did she sustain any injury to her neck? Perfectly fine question. Well, at most, in my opinion, she suffered a mild neck sprain. Now, what was that based on? Answer. That's based on looking at the photographs of the collision.
Ironically, he actually gave that to the plaintiff, and we would point out that this was a traumatic brain injury case, and the real fight in this case was about a concussion. I would suggest that that wasn't proved in this case, and the jury, ironically, did find that even though this was a low, or whatever the damage showed, they did find that the plaintiff was injured to some degree. We know that for 100% because of
the injuries that were being, that's interesting to me, because as Judge Ditkoff's pointed out a number of times, we don't have the whole transcript. The injury that the plaintiff was seeking, the principal injury that her medical experts testified to, sorry, his?
There was no live testimony from the plaintiffs. There was no live plaintiff experts, Your Honor. It was just a defendant's expert. The plaintiff submitted various medical records, bills, reports.
Included concussions?
To prosecute the claim, saying that Ms. LACCETTI had a concussion because of this accident. Absolutely, Your Honor. That was the huge
And that was what was argued to the jury, was concussion, neck injury?
Yes.
What else?
Predominantly that.
Okay.
That's right, Your Honor. And I think the verdict, I mean, obviously we don't know exactly what happened, but I mean, I think it's pretty clear that they gave her, they said probably some soft tissue injury, they limited it. But again, I think this is just, I understand why they did this motion, because the damage, you know, in my assessment, and I'm sure you've seen the photos, was not that substantial. Obviously, that's not good for their case. So that's why they wanted to try to keep it out. But this is keeping important evidence from the jury. This is keeping the truth from the jury. In the cases that we cite, you know, this is
Imagine
relevant.
when the damage is greater, even Mr. Simon's law firm wants to put that evidence in.
Your Honor, respectfully, I think if you were to rule something like the one jurisdiction Delaware case, that would be, plaintiffs' firms would be coming after Mr. Simons, because now every time they have a big, you know, an accident, there's damages, now they can't put it in. The only way that they can do this, even like in a district court case, they'd have to go out and hire a biomechanical expert to basically state the obvious.
Yeah, well, he's not responsible to plaintiff's bar, just to his client.
Your Honors have any other questions? I would point out one other thing, Your Honor.
Just going back to the example that Judge Englander mentioned when your expert was on the stand. The analogy that springs to mind for me is, as at least someone of my age, you can get injured bending over in a particular way to get a leaf. Now, it's frankly more likely if I bend over in a certain way and pick up a barbell. But to the extent you start drawing conclusions that, oh,
He wasn't injured because it was a leaf, then that starts to push up
against
something that is scientifically unsound.
and/or outside the expert's expertise. And here you had a qualified expert, medical expert,
And starts to say,
I drew a conclusion about the injuries based on the property damage, and that
seems problematic.
I think, Your Honor, all of this, you don't have the full record, as you pointed out. This is taken out of context. And it was a factor that a medical expert considered. There was foundation that was laid. Obviously, if you go to the doctor, what type of accident was it? Was it, they needed the jaws of life to get me out, or, well, it was really just a scrape. You cannot say, I would respectfully argue, you cannot say that a doctor would not utilize that information as part of the opinion. And that wasn't completely what he based all of his opinions on. Again, you
Did
take
he say
it out
what
of
you
context.
just said when you were laying the foundation? Did he say one of the things that I have considered as part of I want to see the photographs of the collision?
He didn't say that. We talked about the severity and the different severities of the accident, how that can be a factor. And respectfully, I think that would be, for any doctor, that's obviously important information. Again, not the only information that Dr. Dalton considered. He had all of the medical records. He did quite a substantial analysis.
While you were in the car, how fast were you going?
It's only a part of the piece of the puzzle to be considered. And about the scientific literature, that, as you pointed out, was not, actually should not be part of this record. It wasn't attached to the motion limine. It wasn't part of the underlying trial. It wasn't something considered by Judge Deacon. And it's, again,
not part of the record on appeal, but it's sure helpful for us to get them instead of just citations. We do appreciate someone copying them for us.
Okay. But again, it wasn't, I suggest that it's not, this isn't de novo, it's abuse of discretion. This wasn't something that actually should have even been part of this record before you. And as you pointed out, these are just some, there's other articles out there. And the other courts, if you look at it, none of them get into the weeds with the scientific literature. It's all about common sense. It's all about, this is what all the other 48 states are doing. It's all, very clear-cut common sense issues. There's no other questions. I'll yield the rest of my time. Thank you.
Thank you both very much. The case is now submitted. And our next and last case is 2022 P498, Abdulky versus Lubin Meyer, PC.
Good morning, Your Honors. May it please the Court. Joseph Lipchitz on behalf of the appellants Lubin and Meyer, Andrew Meyer and KRISTIANA, collectively Lubin and Meyer. The heart of this interlocutory appeal involves the judicial approval of a $6 million settlement for a minor child pursuant to Chapter 231, Section 140C.5, in which Judge Lemire found, over the parents' objections and before final judgment entered, that the settlement was voluntary, wasn't entered into under any duress.
Where is that finding? Where will I find that finding in the record? I didn't see that.
That it was voluntary?
Yeah.
In the transcripts itself?
Well, something he says when he's talking to the person isn't really what we think of as a judgment.
Okay. How about the uncontested facts where the plaintiffs admit that those issues were raised and rejected by the court, including the voluntariness and the best interest and the adequacy?
But I've never heard that a denial of a motion to vacate is the stuff of collateral estoppel. A judgment, sure, but of course that stuff's raised in a motion to vacate written by your clients. But yeah, is is something that gets rejected in a motion to vacate collateral estoppel?
Yes, and the rule of law is anytime an issue is raised for determined and determined, that...
So how do we know Judge Lemire...
to be fully and fairly litigated.
How does Judge Lemire know, how do we know Judge Lemire decided that? He could have, since it's discretionary in a motion to vacate, he could have decided discretionarily he was denying the motion to vacate regardless of this duress and lack of information claim.
Well, several things. Let's take them each in turn. On your question about the motion to vacate, I'd cite to the Restatement of Judgments, Section 27, Comment D, and specifically the illustrations 10 and 11, which talk about the fact that many motions constitute collateral estoppel as examples of when you raise things by motion for determination and they're determined, that counts for collateral estoppel. So I wanted to address that. Second, as to your point as to whether he ruled on it, he ruled on it. We attached his denial of the motion.
Yeah, all I just wrote is after hearing denied. We don't know whether he denied it on discretionary grounds or denied it because he actually concluded somehow that there was no duress or that they had enough information.
Well, let's deal with the duress piece first, Your Honor. So on whether he found that they were not under duress, you have the hearing transcripts where he specifically finds that they weren't under any duress or coercion. And in fact, you have a colloquy during one of the hearings where he points out to the plaintiffs, you picked up the phone in my chambers and called Lubin Meyer and directed them to settle the case, and you
How
weren't
can there
under
be
any
collateral
duress.
estoppel based on something a judge says in the middle of a hearing? That's new to me.
Well, because there's two issues there. First of all, on October 2nd, there was a petition for the approval of a settlement. That was action that he had to rule on, and as part of ruling on that petition, he had to find whether the settlement was voluntary. Second, he had their motion to vacate.
Why did he have to find that? The statute just says the trial court may review and approve a settlement for damages, and I didn't see anywhere where he said, I find this is voluntary in anything he wrote or any order he issued.
Well, the voluntariness, he clearly found it right on the record in the hearing transcripts, Your Honor. In order to whether it was essential to a final judgment, if any agreement is not voluntarily entered into, you don't have a settlement agreement. Well, this is an issue that they raised, re-raised, and he rejected.
Here's if it was voluntary. And I don't mean to be facetious. I really want to drill down on, very much as Justice Ditkoff is doing, on what the issues are that you want the plaintiff to be collaterally estopped on. So one is that they executed the settlement agreement under duress. Frankly, let's leave that one aside, okay? We'll assume for the rest of what I need to talk about that, in fact, there was a finding that it wasn't under duress. What else? So the plaintiff now comes in and says, my lawyers committed malpractice because, in particular, as I understand it, they did not find out how much this life plan was going to cost before they recommended the settlement to me. What is it about what Judge Lemire did prior to judgment that collaterally estops that fundamental argument?
Okay. Just to clarify the point of your question, just so I want to make sure, the issues that they raised, and it's uncontested fact 86 and 87, as part of the legal malpractice, their malpractice claims, and they admit they're the same precise issues they raised before Judge Lemire, is that number one, we were under duress at the time of the settlement because our lawyers accurately, uncontested, accurately informed.
Can we leave duress aside? You're not answering my question. What is the other issue that you think they're precluded by?
The other issue was the claim that the settlement was inadequate because it supposedly did not take into account the future costs of
Did
prosthetics.
Judge Lemire decide that?
He did.
On what basis?
And he decided that on the basis that it was favorable and just, huge, and in the child's best
Has nothing to
interest.
do with the question that you just posed, which is whether or not the settlement had an issue because they hadn't considered the true value of this life plan for his prosthetic.
But in coming to that conclusion that it was favorable and just in the best interest of the child, he necessarily had to determine that it was adequate for the child.
On what basis did Judge Lemire have facts in front of him from which he could conclude that the life plan had been properly considered?
There's no life plan, which is the future costs of prosthetics, is that he had their motion. He had their motion that attached the Emerson letter to it, and he denied that motion, and he found that it was favorable and just for the child. So he dealt squarely with that issue.
Well, wait a second. So their motion says, we want to be relieved from the settlement, and one of the reasons is that that they have not considered what the cost of the prosthetic is going to be, the proper cost of the prosthetic. And Judge Lemire denied that motion, and therefore you say that's conclusive as to that issue.
Yes.
How was that issue litigated before him?
Because it was raised, determined, and rejected, and they admit, again, that
He didn't take any evidence on the subject.
He didn't need to take any evidence as a matter of law. You don't have to have a trial or an evidentiary hearing, as our case law.
Well, you have to have a full and fair, in order to have collateral estoppel, since the beginning of time, as I understand it, it has to be fully and fairly litigated.
But you can have something that's fully and fairly litigated by simply raising it in a motion and having it be presented to the court for determination. That's what the Restatement Second of Judgments, Section 27 says.
So the defendants say, sorry, the plaintiffs now say to the judge, hey, we want this reopened because of X. Your folks put in no evidence on that subject, none. There's no evidence before the judge as to what they had considered with respect to the cost of the prosthetic over time. And yet you say his conclusion, rejecting that, is collateral estoppel.
Yes, and it's because he had to make a determination over whether it was in the best interest of Anthony. It's uncontested that he did. It's also uncontested.
Well, is it uncontested? Where does the judge find this is in the best interest of Anthony?
It's uncontested fact number 74. It's uncontested fact number 77, where the plaintiffs admit themselves that failed to contest the fact that the judge found that this settlement was in the best interest of Anthony, repeatedly throughout the summary judgment record. And stepping backwards just slightly from collateral estoppel, Your Honor, on the issue of...
So let me ask you this. You're at a settlement position, and because someone's lawyers were incompetent, they didn't get a prostheticist. And so at that point, might a settlement be fair and just? Because one of the things the judge has to consider is the context, and he's not going to let them start the case over again. Let me give a hypothetical, since obviously that's too on the point. You have a trial, and at the trial, the plaintiff's lawyers totally screw it up. They don't bring in the expert, they don't prep the expert, and then halfway through the trial, they say, okay, well, we got a settlement here. And the judge says, well, okay, that settlement's fair and just, but isn't he saying fair and just in light of how the case has been litigated so far?
I think the answer to that is no, because 140C.5 creates this mechanism by statute where judges are stepping into the shoes of that minor child to protect them and determine whether that settlement is in the best interests of the child.
And you believe the statute requires a judge to figure out what the proper settlement would be if the lawyers were better?
No, it doesn't require it to make the determination about what it would be if the lawyers were better or worse. It's making a determination of whether it's in the best interest of that minor child.
But it might be in the best interest of that child because he's stuck with the bad lawyering he's gotten so far.
Who do you think the ruling on 140C1/2 is supposed to protect?
I think it's designed to protect litigants. I think it's designed to protect the judiciary system. It's designed to protect the lawyers that appear before judges.
What do you, well, so that's great. That is an absolutely perfect answer as to the panoply of people who it might be intended to protect. I did a little research. I'm not so sure that there's an answer yet. And I think it's critical, right? Because I think it's critical to, your argument is basically, look, there's a process. Process has a purpose. When the process is done, this case is trying to reopen that process, right? And as I was thinking about that, I said, well, it's at least supposed to protect, I think, the parents, because the parents shouldn't be sued by their minor child somewhere down the road because they took $800,000 out of the $6 million settlement or whatever it is, okay? I mean, it's got to have some impact, otherwise why are we doing this? At least that's what I'm thinking, but I don't know. Can you point me to anything, any case law, any legislative history, anything that tells me what is the preclusive effect of this supposed to be? Because you need to get to the third thing you said. You need to get us to conclude that it's intended to protect the child's lawyers. If it's intended to protect the child's lawyers, then it seems to me your argument maybe has legs, right?
Yeah, and I think it's designed to protect finality. To your point, the case law on this, at least from the appellate...
Well, we got finality because this is final. The only question is whether your clients have to pay, not whether the doctors have to pay.
Right, but the whole point of the statute is to protect the best interests of the child, also against the parents who may be acting in an irrational way to his detriment.
I mean, that's what I would have thought, but if the purpose of the statute is to protect the best interests of the child, how can it be used to stop a lawsuit by the child?
Because you have the judge stepping into the shoes of the child to make that determination. And I think it's also important on this notion...
I think it's more than protecting the best interests of the child. I think it's protecting the parents, because that's my sense. I mean, why would it says any party can raise this, right? That's what the statute says. So it's allowing people in this awkward circumstance where parents are representing their children for that to be laid to rest. The child's not going to come back later, sue the parents because they didn't do the right job in protecting the child. We're going to put a judge in between. The judge is going to make a decision. But why should it protect the lawyers if the lawyers didn't do their job?
Well, the lawyers did do their job here, and I'll get to that in a second here. But we cite the secondary authority. There's some MCLEs and secondary authority that we cite also that suggest that it's designed to protect lawyers from...
But did the MCLE cite a case? I mean, do we have a case? Do we have legislative history? Because honestly, what somebody wrote in an MCLE is not authority.
All I can tell you is the appellate law that we have on this is Sharon versus City of Newton, which the SJC referenced the purpose.
I want to ask a very particular question as we're running out of time. You are saying, if I understand part of your argument, that we, the panel, does not have jurisdiction to consider whether or not the single justice improvidently allowed interlocutory review because they didn't appeal her ruling. Is that a fair statement?
No, I don't believe that's not
how
my argument. If I'm understanding your question appropriately.
Well, the question is, this is an unusual appeal given its interlocutory nature. And
it
it's
is.
Specifically blessed by the single justice.
Yes.
Do we have the authority, if we will conclude, this is pure hypothetical, that she was wrong about allowing an interlocutory appeal to reach that question and say, no, we're not going to allow, we're going to wait until this matter is over and take an appeal, if at all, at that time? I thought I got from your brief that we couldn't do that because they didn't appeal the single justice's order.
No, I didn't think.
I guess I'm reading too much into it.
Yeah, I think.
So could we?
I think once the Rule 5 of the appellate procedure and the case law makes it clear that when a single justice refers a case to the full panel, that matters before the panel for all purposes on the merits.
No, but my point is,
If it had been a report as such, the trial judge reported the issue, we always have the option of saying,
this report,
we're going to deny. We're not going to
discharge, thank you, I was looking for the verb.
we will discharge the report because
We disagree that this is proper for us to hear the appeal now.
do we still have that authority?
I believe you would, sitting as the panel.
Okay, I misread your brief.
Hold on. This is a really complicated case, and we have, in my view, we've touched 1 out of 3 significant issues and 1 out of the 2 issues that I want to talk about. And I just want another one. Most of my questions are going to be for your brother, so let me just ask. As I understand it, summary judgment raised, collateral estoppel, judicial estoppel, failure to prove damages, failure to have any evidence from which a jury could conclude that the plaintiff had been damaged, right?
Well, on the last point, it was the failure that they did not have admissible expert testimony on causation and damages.
Causation of damage. I think it's more damage, right? It's that there's anything more than $6 million that would have been recovered had the lawyers done their job.
And it actually netted, just so the $6 million.
7 point whatever.
Yeah.
Right, got it. Now, was there oral argument?
On which?
On the motion for summary judgment?
Yes, there was.
Okay. So, and then all we have as to how she decided it is that 4-line order or whatever it is, right?
Yeah, and I believe we did attach this.
During the motion hearing before Judge Kenton Walker, was there discussion about the quality of the evidence that the plaintiff put forward on the question of damage or causation of damage?
Yes, so and the transcript is in the record for that summary judgment argument.
Good.
We specifically attacked, as we did on our motion briefs, that the expert opinions were inadmissible because they fundamentally failed Daubert Lanigan. And plaintiff's counsel didn't really make an argument, but rested on the briefs.
There is a reference in their expert's report, the expert who says 10 million, to an affidavit of somebody named Schulte or something like that, who I think says that the plan, the prosthetics would have, there's a description I've seen somewhere that's $5 million. Was that in the summary judgment record?
It was.
It's in the record? How was it in the record? Who put it in?
The plaintiffs did.
Plaintiff's expert does not rely on it when they say $10 million.
I know that, yes.
Okay. All right.
Counsel, I'm afraid your time is 5 minutes over.
Thank you, Your Honor.
Thank you very much. We'll hear from.
Oh, I'm sorry. Is there something I'm missing?
No,
you were about to say something.
I was confused because you had raised a number of issues. I thought you wanted to hear on the other issues, but.
That's what I was most concerned about.
Okay. Thank you.
Thank you, counsel.
Good afternoon, members of the panel. May it please the court, Peter Brockman for the plaintiffs. Just to address Justice Milkey's question about whether this panel can review the single justice's decision to grant this extraordinary relief under Mass Rule of Appellate Procedure 15, this panel can review that decision. And I'd like to start off with that because I don't think that it is properly before this panel.
Well, I mean, your argument in your brief appears to be we have to get rid of this. In between, we have to get rid of it, and we don't have jurisdiction to consider whether she erred, is a middle ground where we could theoretically find that this was improvidently granted. Which realm are you in?
Well, I think, if I understand your question correctly, that as a preliminary matter, I'm saying there's no need for this court to address this appeal because it's not properly before it. Because I think the single justice was improper in granting the petition.
Proper as a matter of law or abused her discretion? Because I mean, clearly a single justice
Can determine that an interlocutory appeal that otherwise wouldn't be appealable should be heard.
I agree with that, Your Honor. I don't dispute that. But I think that the case law says that it has to be some kind of serious or irreparable consequence that is being addressed.
Why isn't it a serious consequence that they have to defend against a case that the law says they shouldn't have to defend against? If you assume what I just said, let's assume that the law is, as your brother says, either that the 140C and a half concluded your case, or maybe that he's got some other argument that shows that summary judgment should have been granted as a matter of law. Why isn't that a serious consequence?
Well, then every case, Your Honor, could come before this panel on appeal.
Only the ones in which a single justice makes the conclusion that it's extraordinary enough to allow it to come up.
But I think if you don't have some limitations on the ability to appeal an interlocutory order, that you're going to be very, very busy.
Well, I couldn't agree with you more. I just think we've got more than some limitations. We have law that says you can't unless you go to a single justice who, applying some very stringent standards, decides that they're going to let us have it. So, anyway.
Well, and I think that in this case, there are no serious or irreparable consequences. This case can continue on to trial. Everybody's rights and remedies are preserved. There's no prejudice.
There's a lot of other stuff to cover here. Maybe we should get to that.
That is correct, Your Honor. The other thing I just wanted to say is, even if the panel agrees that the single justice was proper in sending this matter to the panel, in the petition for interlocutory review, there was absolutely no mention.
But the whole issue comes to us. Your brother says the whole motion comes to us, doesn't it?
No, I don't think so.
Really?
I mean, because their petition did not mention judicial estoppel. There's no mention in there.
But their motion for summary judgment did.
Well, that's correct, Your Honor, but I don't think it's fair to assume then that they're seeking this extraordinary relief for everything.
I don't assume anything. The single justice reported to us whether the denial of the motion for summary judgment was proper or not. Didn't say, I'm only reporting up this issue, that issue. In fact, when you asked for that clarification, denied it.
That's correct, Your Honor, and I think I had to do that to preserve my right to argue that.
I would have done the same thing, but I mean, it was denied, so here's where we are.
Let's talk about collateral estoppel.
Okay.
And then, please, we're going to need to reserve some time to talk about damages. And if you want to address judicial estoppel, by all means.
Okay.
Start with collateral estoppel.
So, Your Honor, collateral estoppel does not apply here, and the lower court was proper in not being persuaded that it does apply here. First, with respect to the review by Judge Lemire of the settlement, that's all this is a settlement. It was something that Judge Lemire essentially mediated and resulted in a settlement. And under 140C and 1/2, the judge had the discretion to review that. Judge Lemire was not required to do so.
Wait a second. I'm not sure I agree with that, because it says they may on request of the parties, but you really think the judge could say, oh, I'm not going to do a 140C and 1/2 review, even though the request otherwise, really?
I think so. As unusual as that may seem.
But let's get past that, because he did, in fact, do it, right?
He did.
Okay. So, what's the consequence of having done that and having issued a ruling?
Well, with respect to collateral estoppel, the issues have to be the same. The issue before Judge Lemire was this settlement in the best interest of Anthony?
That, again, and now I'm going to be parroting Judge Milkey, I think, to some extent. That's not what the statute says. Statute says review and approve. It doesn't say anything about the best interest of the child. It's not the language.
Well, there's case law out there that talks about the fact that it is in the best interest of the child, that is the standard.
What case law says that? I struggled to find case law about 1-4. I'm not being facetious, and I know I've been tough on your brother. There does not appear to me to be anything here in the law that's helping understand what happened. In other words, what's the legal significance of this process that is statutorily set up? And so we have a process, and the process says, if party asks, the judge makes a decision. He reviews and approves, and that appears to have happened here. And is there a consequence to that? To some extent, I hear you arguing, no, there's no consequence to that. A lawsuit can follow that challenges whether or not that settlement was appropriate, whether that settlement was for the right amount. Is that what you're arguing?
I think there are two different tests. So the test that was before Judge Lemire is different than the test in this case. This case is not about the best interest of the child. This case is about, did these defendants breach their duty, and if so, were their damages flowing to the Abdulkys?
Does anyone get protected by the judge's finding at the request of a party that he's going to approve the settlement?
No, I think
You agree with me that he at least made a finding approving the settlement?
I agree.
Okay. So what's the consequence of that?
Well, it protects the defendants in the tort action, correct?
Well, I mean, I think my brother was probably accurate about who it protects.
He doesn't need to protect the defendants, I don't think. The defendants get a release. That's what they get.
Well, that's
and they
correct.
get res judicata. They get a dismissal and res judicata. It's got to be protecting somebody other than these defendants.
Absolutely, Your Honor. And those defendants are not these defendants.
I understand that.
Where I'm not trying to undo something with respect to them. That I cannot do and would not do.
Could you sue the parents once the child came of majority?
I wouldn't take that case, but could it happen when the child reaches majority? That was a real concern.
I say we went through exactly this process so that I didn't get sued for that. And now I can still get sued?
I think, the parents were certainly concerned about the adequacy of this settlement. I don't think they were concerned about their child turning around and suing them, but what they had foremost in their minds was this settlement adequate?
Yeah, you're kind of going off on a tangent. I'm asking a hypothetical question. Does it protect the parents?
You could certainly make that argument.
Why doesn't it also protect the child's lawyer?
That may be one class that's not protected by this. And certainly in this instance, where the lawyers did not prepare this case properly, and it ended up being settled for a number pulled out of thin air, I think it would be inappropriate to say that this process is to protect the lawyers, the defendants, plaintiffs' lawyers.
Well, we don't have anything that tells us, right? We don't have legislative history. We don't have other case law. We're trying to figure out the consequence of a process that occurred, that appeared to occur to protect someone other than the defendants, and who it protected.
I think first and foremost, it protects the child. I think that's what the case is.
I think that's right too. I think it is intended to protect the child, and maybe that's an answer. Maybe the answer is all it's really supposed to do is ensure that what's going on then is adequate. not to try to protect against a subsequent.
That's correct. I think that's correct, Your Honor. And to get back to your earlier point where you mentioned actually litigated, that term appears in a lot of these cases. And here, it wasn't actual litigation. It was essentially a mediation conducted by Judge Lemire that did not have any sworn testimony whatsoever. The Abdulkys were never sworn in. No one was ever sworn in. There was no evidence. There was no expert brought in. Those issues, damages were never litigated. This was a settlement that received judicial...
Sure, the medical malpractice was never litigated, but the 140C.5 thing, whatever that is, was litigated, and so was the motion to vacate. So why aren't those things that were actually litigated matter here?
Yeah, that would be a question for the Abdulkys' prior counsel, I think. I don't know what the reasoning was for not taking pursuing other avenues after that was settled and approved.
I'm not asking why they didn't appeal. It's very plain why there was no appeal, because they were told that if you appeal, you get nothing at all. I mean, so it's like right in the record. But what I'm asking is, they actually litigated the approval of the settlement, and they actually litigated whether to vacate the settlement, which is really the same thing, just different arguments for it. So those are two things that were actually litigated. So why don't those have collateral estoppel consequences? Whether or not they bar this lawsuit, why don't those things have collateral estoppel consequences?
Well, they would if I was arguing in this case that the Abdulkys were under duress, but that's not part of this case. So we're not trying to undo that settlement agreement.
So can you tell me what to make of this thing your friend pointed out, which is we have the statement of facts, and one of the facts is Mr. Abdulky, who is not, I understand, the only party here, right? He admits the basis for his claim are duress and not adequately determining the future costs, citing his wife's deposition, I gather, not his deposition. So what do we do with that? Why doesn't that control, or to what degree does that control what your basis have to be for your lawsuit now?
Well, I think
deny that.
Looking at the pleading itself, the pleading itself does not seek to relieve the Abdulkys from the settlement agreement based on duress. That's not part of this case. The issues in this case, as clearly set forth in the pleading, is whether the lawyers properly prepared the case, breached their duty to their clients.
So why didn't you write, I deny this, that's not the basis of our lawsuit at all, in the statement of uncontested facts or material facts?
I'd have to look specifically at that to see what language I actually used. But I think the record is replete with, to establish that the issues are different than the issues that were before Judge Lemire. And therefore, their collateral estoppel does not apply.
Counsel, time is getting short, and my colleague to my left has a number of questions regarding damages.
So, they file a motion for summary judgment, and they say, you have not established that there's a damage from the $6 million settlement, right? That's an argument they made?
That's correct.
What evidence did you put?
So there
be admissible, which would be admissible at trial, to show that there was something that could be taken to the jury that in fact they should have received more than what they received.
Okay. The affidavit of a seasoned, experienced malpractice attorney who...
Supplemental affidavit?
Excuse me?
This is the supplemental affidavit in Appendix 2? you're talking about?
Yes, there's an affidavit and a supplemental affidavit.
Where's the original affidavit? I didn't see that.
It would have been part of the summary judgment, would have been part of the summary judgment papers.
He says $10 million. I think this case is worth $10 million. Is that going to be admissible at trial?
Absolutely. Because
On what basis
keep in mind,
would a judge allow that to be admitted at trial?
the burden is not to show with any scientific specificity what number would have been achieved, but for the attorney's malpractice. We just have to show that we would probably have achieved better had the malpractice not occurred. So there has to be just a probability, and that affidavit meets that burden.
How? How is what your expert says something that a judge could admit? It has to be based on some reliable methodology. Would you agree with that?
I would agree with that, or...
And where does your affidavit indicate his reliable methodology from which he has concluded that the case is worth more than, when I said $6 million, your brother said actually it's worth more than that. So where is it, the reliable methodology shown that the case was worth more than the settlement that was reached?
Well, and I think in the expert's affidavit, he says that based upon his research on verdicts, and reported settlements, that this case would have...
And that's a reliable methodology? I did some research, $10 million.
The affidavit, I think, absolutely meets the burden. At the summary judgment level, absolutely.
No. See, that's the problem with your opposition, I think, counsel. At the summary judgment level is not different. At the summary judgment level, you need to put forward such facts as will be admissible in evidence. And there are plenty of cases out there where courts have said that expert report ain't good enough to establish a genuine issue of material fact.
Well, isn't that go to the weight of that evidence, Your Honor?
No, it goes to whether or not it's admissible. The judge is the gatekeeper. The judge is going to, if asked to, which the judge was by the briefs, if asked to determine whether or not what is in that expert report is sufficient to make it admissible, at summary judgment, the judge should do that. Now, if you've got something that tells me I'm wrong about that, have at it. But that's why, even though the red light is flashing, we're still having this conversation, because this is important to me, at least. It may not be important to anybody else on the bench, I'll tell you that, but, okay?
I understand. I
mean, am I wrong that that's what the law is? That if asked to, we have to look at, we meaning starting with the judge at summary judgment at the trial level, look at what the expert report shows and see if it sets forth such facts as shall be admissible in evidence.
Well, I think, at the summary judgment level, Your Honor, it's a lower standard than at trial. I mean, this expert is going to testify in person at trial.
Do you have a case that says what you just said?
If I do, Your Honor, it would be in my brief.
I will take a hard look at that. I know you said some of these things in your brief. It would be not consistent with my experience, having done a lot of this in my lifetime, but I'll take a look. Okay.
Thank you both very much.
Thank
Very
you.
interesting case, and the case is now submitted, and this concludes our hearing today. Our thanks to the court officers, the law clerks, and the clerks for all their great help in managing this hearing. We are concluded. Thank you.
All rise, please.